sometimes like all you want to do is run. Hear me out, hear me out. It's all the things you never show. There are the things I want you to know. Secrets start in your heart to slow. But if you don't want to tell me now, I guess I'll never know. Losing almost all my energy. It's getting hard to talk to you, and I'm the only one who speaks. It's all the things you never show. There are the things I want to know. Secrets start in your heart to slow. But if you don't want to tell me now, I guess I'll never know.
Okay. Hey guys, welcome to the live. Sorry for the late start, but it's going to be well worth it, of course. Everyone can turn on their cameras now. Or, so anyway, of course, Travis is with us tonight. So that's Travis Williamson, and he's a lawyer, a legal analysis. So thank you very much. And Alexa's here as well, joining us, and we're going to be going over the latest documents. But first, I want to say to Travis, thank you so much for joining us tonight. So appreciated. Hey,
Thank you.
everyone. Oh, Travis, here. Yeah, there you go.
Thanks for having me. Thanks for having me. Yeah.
No, thanks for joining us.
Exciting
Yeah.
stuff. Can't even keep up. Can't even keep up.
By chance, Travis, did you just want to give a quick synopsis of what you do, just so people understand exactly who you are?
I'm an attorney. I practice primarily in Central Texas, Austin area. I do civil rights defense, represent, and criminal defense. I do a lot of work representing police officers, but all kinds of criminal matters. And I've been admitted to practice law since 1986. The first 10 years of my practice were civil litigation with medical malpractice defense. I defended doctors and hospitals. And then I got into employment law and representing all kinds of employers, and then eventually got to where I represent firefighters and police officers in Central Texas on a wide variety of matters, but essentially trial law for well over 35 years. So,
Yeah.
and I like to educate the public in true crime cases, not necessarily about the true crime case, but about the law associated with it, and they can understand what's happening legally and how our criminal justice process works, or rather in this case is supposed to work.
Yeah.
So that's pretty much it. And I'm glad to be here. Thanks for inviting me on.
No, thank you. Like, I know you've been looking at a lot of documents today, and today's been pretty crazy with all the different
well, you'd send me one and go, I just got this, and then I'd work on that and trying to anticipate what questions your viewers would have, and then 2 hours later you'd send me another one. This just came in, and so yeah, it's interesting, but that's fun. Makes it all worthwhile, right?
Well, I was gonna say, because for myself,
how we feel without your knowledge,
right? Yeah, honestly, like you're like a saving grace on this one.
Sincerely, I've said this in your chats before. y'all do a very wonderful job on the law. You really do. And
Thank you.
Oh,
Sonny
thank you.
said the other day, you know, a lot of it's common sense. It really is common sense. Not always, but on the common sense part of it, you and Adam, you know, from what I've heard, do a very wonderful job of explaining it. So, hats off.
Yeah,
Thank you.
Adam more so on that, I would say. But at the end of the day, kind of like what we've talked about, right? At the end of the day, this is about the fact that you want, like, regardless if it's about Delphi or not, regardless, you just simply want, the truth. You want to kind of like give the documents and the facts as they come, but you just want a fair trial. You want justice for the victims of the families, and knowing that there's all these different court filings that come along, of course, with this. And like today, for instance, as you're aware, some days just get really intense because there's just, like you said, like, documents after documents coming along. So please appreciate yourself for highlighting certain things that you're going to be talking about today. For anyone else that sent me documents today as well, Frank Meister, Alexa, and Charmaine, I want to thank you guys for, like I said, pushing along documents towards me as well. It was a very hectic day, but I'm so looking forward to it as well, and your advice. And of course, you guys, Alexa's in the house. Say, Alexa's mic's off though.
Hi, how are you? Thank you for having me.
Thank you for joining
Yeah.
us.
Yeah, and Alexa, of course, is our criminal profiler. Actually, Alexa, you go ahead and tell it again.
Sure, I work as a crime and intelligence behavioral analyst and body language expert, graphologist. So I did anything from crime data to body analysis, graphology, of course. And the main one was profiling and crime scene investigation.
I know Alexa's had a long day herself, guys. So
Yeah,
just truly
I'm sorry.
appreciate you guys being here. No, don't you never apologize for that. I know how it goes. When you got kids and the day's hectic and stuff like that. Same with Travis over here. It's been a long day, I'm sure, definitely for him as well, and everybody. Adam just got off work, raced to his, home type of thing, his parents' home there, and anyway. So okay, so thank you guys for joining us today. Please hit the like button. Please show a lot of hearts and love, of course, for Alexa and Travis that have joined us today. And, let's just get started, I guess, with this first document that we have in front of us.
Right. Hey, everyone in chat, by the way.
Yeah.
Sonny, would you like me to read this letter?
Well, I was going to say, Travis, he's on mute right now.
Oh.
Because I don't know that he wanted to necessarily
Yes, Sonny.
read. Okay, sorry. This document here.
Yes, Sonny.
Can you hear?
I'm here.
You good?
Yes, I can hear you
Can you
loud
hear
and
me?
clear.
Okay, so this document that's before us, are we going to be reading through it, or are you just going to give the gist, or are we going to be reading through this one document here?
It's your guys' show. If you want to read it, I guess I can live through it, but I would just prefer to highlight it. But
Yes, absolutely.
if y'all want to read it, we can.
Travis,
Actually,
I
I'd
don't
like
know. You're lagging
Adam
all of a sudden.
to okay, first.
It's funny. Backstage,
Wanting to come back on it. Pro bono.
Travis, I'm
he's not going to get paid. He's going to volunteer. But it doesn't officially file.
Travis.
Yes.
Can you do me a favor and maybe go back out and then come back in? Because for whatever reason, you just started lagging. And your voice is becoming technotronic almost.
Should I go out and come back in?
Yeah.
Yes, just go out and come back in through the link again and just see if that fixes it.
Okay. Well, everyone,
so
we had
funny.
a lawyer with us for a little bit tonight. He gave us some great information, but everyone have a good night. Okay.
Well, that's it's so funny because he was just fine, and
Yeah.
and then all of a sudden, then it just went very laggy. But there's nothing worse when somebody's talking and then they're lagging in and out, and you're only getting bits and pieces of what they're saying. So we'll just give him a second there.
It was probably defense diaries. They're like, nope, we're the only ones that can talk about this stuff.
No, I remember I caught them for a little bit there. They had like over 800 viewers at probably the peak. It might have been higher, but I had to get going.
Same.
Yeah, for Travis went into this. So this first one actually just came out. Actually, Defense Diaries posted it, and that's when I seen it. And I was like, wait, what? Because it was head breaking right across. Oh, there. Let's
Here
see.
he is.
Okay. Ooh. Let's see.
Hey there, I'm back.
Okay. Let's see if that's better now. Because you were
Yes.
just fine in the back room, and then all of a sudden you started lagging just when you were playing with something, and then all of a sudden everything just went wonky and I could barely hear your voice. So let's see if it's better. Are you better?
That's typical. When you put me on the spot, I start lagging.
On there. Okay. So
I feel fine, but we'll see.
you said you sound better right now. You're definitely sound better. Okay. So with this
Is it
pro
better?
bono,
Okay.
it is better. Let's knock on wood. Okay. So with this pro bono appearance form, again, just give your your briefing over it.
Yeah. So do we know if it's been filed? Is it mentioned in the clerk's record, clerk's
It's
docket?
not. I'll the only thing I've seen is this screenshot that's been the Defense Diaries put out. I've gotten it from a few different people tonight. It could be a letter of intent. We don't know if it's actually legit or not yet.
Okay. Okay. Well, if it is legit, what he's attempting to do is say, okay, look, I'm off apparently as a court-appointed attorney, so I'm going to come back in as a hired attorney, but on a pro bono basis, meaning he won't get paid. So, Adam, if you could read that B part, it says Attorney Baldwin. If you could read that part.
Yeah, it says Attorney Baldwin enters his appearance as Mr. Allen's privately contracted lawyer. Attorney Baldwin acknowledges his prior representation of Mr. Allen as his contracted public defender and reaffirms that he, Attorney Baldwin, did not and has not voluntarily withdrawn from Mr. Allen's case in said capacity. The filing of this appearance is intended to convert Attorney Baldwin's status as Mr. Allen's public defender to Mr. Allen's private counsel, wherein Attorney Baldwin will move forward with said representation on a pro bono basis in the event that he is not reinstated as Mr. Allen's public defender. With well over 1,000 hours of time spent reviewing evidence, analyzing evidence, and preparing Mr. Allen's case for trial, and with the desire to have the court hear suppression evidence, and the desire, it's a lot of ands, and the desire to get this case in front of a jury as soon as possible in order to honor Mr. Allen's 4th, 5th, and 6th Amendment rights, Attorney Baldwin enters his appearance.
Wow, so that's really surprising, amazing. Someone just posted a question: how many attorneys is he going to have tomorrow?
Right.
Or
7, 9, 2.
think the
And then how
prosecutors.
many are still on the case or not? Well, if this is a legitimate document and it's actually filed, the judge can't prevent this. I mean, it's an automatic. The judge can't say, no, I'm not going to allow you to be private counsel. Private counsel trumps contract public defender counsel.
Okay.
And there actually been some discussion in various legal communities about, hypothetically, could this happen, that happen? What if Rozzi decided, okay, I'm going to enter an appearance as contract counsel? What if people were able to raise funds for Mr. Allen to hire Baldwin and or Rozzi as private counsel? What would happen? And the general consensus is, if you appear as private counsel, a judge cannot prevent that. Judge can't say no because of what you did prior in the case. I'm not going to allow you back in the case, because what they were presumably, and the status of this thing, I mean, it's just crazy. So supposedly they both voluntarily withdrew. They weren't even removed. So, but in the latest pleadings that have been filed over the last 5-6 days, we now know a fuller story of that they were pressured, coerced, whatever you want to call it, into a Hobson's choice of either agreeing to withdraw during the in-chambers hearing, or they would go out at 2:00 and the judge would read this statement of purported allegations of gross misconduct, and the judge would remove them. So Baldwin said, I moved to withdraw in chambers. She granted that motion, that oral motion, and Rozzi said, well, I'm going to get you something in writing in a couple of days. And, so she cannot prevent one or both of those attorneys coming in as private counsel now, but that raises some other questions. If they come in as private counsel, one or both of them, do they lose the two new public defender attorneys that were appointed? And most jurisdictions, you're going to lose your court-appointed public defender counsel if you have private counsel come in. So, they're both going to go off the case. So the other component of this is, in addition, if you're indigent, you're entitled to court-appointed attorneys. We all know that case is Gideon, and it's developed, right. But that's a case in the early 60s, folks. Before 64, in the U.S., you charged with a felony, except a felony involving the death penalty. You didn't necessarily get a lawyer. So just keep things in perspective. A lot of things we take for granted. But the other component of it is that due process, you're entitled to an attorney to defend you, a competent attorney, not the best attorney, but a competent one. And you also, as part of due process, you're entitled to have your attorney be given funds by the state to hire experts to either review evidence, review the other expert the state may have, and or testify in court about certain matters. You're also entitled to funds for your attorney to hire an investigator to go out and do an investigation, because that's required. If you're appointed as an attorney, you have to conduct an investigation. And so they may pull those funds if he comes in. And we know at a minimum, he's going to need good, competent experts on tool mark, firearms, ballistics, regarding the supposed matching of that unfired shell casing and the exemplar they found at the crime scene. So a lot of stuff's open. This may just be up and ready to go, and he's not going to file it until he knows what's going to happen on these other motions, because
Right.
they're trying to put back in play that the withdrawals were not really withdrawals and that she didn't have authority to appoint other counsel until the motion to disqualify heard. So this may be, what's the expression, kind of a placeholder that, hey, look, if you're going to go forward with this hearing, you're not going to continue it like it was requested in order for these other issues to be decided upon, then I'm just going to enter my appearance, and I'll deal with the consequences of that. But I'm going to represent him. It's really curious to me, because the things that got filed today put everything in a good place in terms of everything being figured out, and then it can move forward from there. And so I'm surprised that he's getting ready or has filed a motion to appear as retained contract counsel.
Right. Oh, and let me ask you quickly. So with all that said, I mean, and my understanding is in Indiana, that if you have private counsel, it would then be up to the defendant or the counsel. If it's pro bono, it would be the counsel themselves paying for those experts and taking on the burden of all of that. So, I get the whole kind of 1 foot in, 1 foot out that, Baldwin seems to be doing in this, where he's like, I want to remain, his public defender because then the state pays for everything. But, with him becoming private counsel, and my understanding is that Rosie apparently wrote a letter the same that has just not been released yet. But
a letter to the same effect.
Yeah. But so my question though is, so how does that affect what is scheduled to happen tomorrow morning at 9 a.m.? I mean, because, the Supreme Court of Indiana is not going to have ruled on anything until apparently November 9th, which we'll talk about in a little bit. But, does that mean, should we expect tomorrow morning to wake up and there's been a continuance for the hearing, or who shows up?
So that's a great question, Adam. Really good question, because, and I am nowhere near up to speed on the history of this thing. I'm pretty much 30 days and seeing this commotion. But in getting prepared for today, for example, and going through the public docket that everybody can look at through my case on indiana.gov, there's a history, and also brought up by some of the motions and the writ that was filed today. There's a history in this case with this court not really knowing what is happening on a particular hearing date. So we know that this date was originally scheduled to be related to the Franks hearing and maybe some other suppression motions, but the events last week of the attorneys being removed / voluntarily withdrew, the judge announced from the bench that she, quote, wanted to keep the 1031 date intact. The only words we heard from the state were the whole morning, afternoon were, yep, that's good with us. We'll be here on the 31st. And my understanding was it was for the new defense attorneys to announce their appearances and maybe talk about a quick couple of things. So
Right. And to
that
set
was
a
my
new trial.
understanding. Say that one more time, Adam. It cut off.
And to set a new trial date, because she
Right.
stated that they didn't expect that they would be up to speed by January.
Right. And exactly right. And that she hoped, but that the former attorneys would help the new attorneys, but would hope that would happen, but isn't expecting it, that they wouldn't have to turn over their work product necessarily. And if people have questions, what's work product, we can answer that for them. But yeah, she said all of that, and or she said it was unexpected too. But so I don't know what tomorrow's scheduled for. So to answer your question, who the hell knows? Because that court doesn't do things in courts that I have seen, and even other Indiana courts in different counties, they list out exactly what is going to happen on that hearing date. And I know you all are familiar with other cases. And I know you've gone through other dockets. You don't see stuff that, it's an ombudsman hearing. That's a frequent one. It's a disposition hearing. That's a plea bargain hearing. It's a motion in limine hearing. Whatever it is, with certain limited exceptions, this stuff that it has not in the public one iota, like a 12:30 in chambers hearing on whether counsel should withdraw or not. I mean, you just don't see that in other courts. So I don't know what's set for tomorrow. And
I think
other than what was announced in open court. Go ahead, Sonny.
No, I was just going to say the same thing. That's how I feel. I don't feel like anyone really knows what's going to actually happen at court tomorrow. Some people were saying that it might not even happen, with these filings, and I don't know. I don't know either.
Well, I mean, like if we go by the fact that, like if we just go by what was said in open court, so that, that tomorrow is to, basically appoint these new attorneys, which have been appointed, and also to set a new trial date. I mean, how does like the stuff that happened today affect that? Or does it? I mean, do they just go about their business and they wait for the Supreme Court to issue an ultimate ruling?
Well, if they were filed, I'd have a more definitive answer. But let's just assume they're filed, or
I mean, I was told they were.
Both those attorneys show up in court tomorrow. The part that you read, what's key about it is that they're saying we're doing this in part to maintain the January trial date, right? And that's critical, because she's going to be hard pressed if they show up and they say, Judge, we need to know what you're going to do on the motion for continuance that Rozzi filed. If you're going to continue this hearing, we'll keep everything status quo. Fancy for everything's going to stay the same, and we'll let some of this stuff get decided. If you plan to proceed forward and maintain this position that these motions that you struck and ordered removed from the system, if you're going to maintain that, we're both going to enter an appearance as contract counsel, and we're ready to proceed today. And then it's our understanding the first thing that you want to discuss is the trial date. We object. We strongly oppose any change in the trial date. We want the trial date just like it is, and that's what would happen tomorrow. And I really like your expression, 1 foot in, 1 foot out. That's the best way to describe it. And maybe why this doesn't have a file stamp on it yet is that they Rozzi filed a motion for continuance, and he listed out these specific things as why he continued it, that these other things are pending, and you should continue that date until these courts can clarify things, the appellate court on the writ, and you can consider our filings. And then there's a motion for rehearing, and I don't even have that, Sonny, but maybe Adam knows what that is. That was filed, one of the most recent documents, motion for rehearing. I'm assuming
the motion to reconsider.
Yes.
Okay.
Yes.
Oh, yeah.
What was that on? Reconsider what? Which motion?
I believe that was to reconsider the removal. I believe that was to reconsider the removal of them as the attorneys.
Okay. All right. But you saying 1 foot in, 1 foot out, that's my best guess, is that they're waiting for the judge to see if she's going to rule on that motion for continuance, which, that wasn't one of the documents she ordered to be removed or stricken. So things are certainly unclear. At least I don't think it was, because she referred to there have been motions filed on such and such a date. They've been removed. I ordered those documents, those motions stricken, filed on whatever date it was, and the clerk removed those from the filing system. So let's see. Scroll down on that motion to reconsider. Go towards the very bottom. Let's get to the meat of it.
Oh.
Up. Let's see. Okay, go down. Okay, stop right there. The court's order to remove appointed counsel. You're exactly right, Adam. It's appealing the quote removal unquote, and for a number of reasons, including that Richard Allen had a right to be present, and that was mentioned in the writ today, that Richard Allen wasn't present in the in-chambers hearing, and he has a right to be present, or at least he would in the states I've practiced in, and so I'm sorry I didn't have a short answer to your question, Adam, but it's a good one. I don't know, but it helped prompt me to think that these documents, if they're legitimate, haven't necessarily been filed yet, because they're going to wait and see what's going on. So that's a huge thing to anybody who's listening. And so now I think we're going to go forward with what we were planning on talking about, which is the writ, which is still applicable. So, go ahead, Sonny.
No, I was just going to say, because I know that time can absolutely get ahead of us, and I'm not sure if you wanted to go on from that now and then move on to this, and we're going to be going into the other, like the writ and stuff like that as well. So I'm just pulling it up whenever you're ready.
You're the boss. If you want to see if anybody has questions right now regarding that new filing, we can do that, or we can go into the writ, and we're going to talk about the attorneys you looked up who signed the writ, 3 of them. I know we're going to go through that, but however you want to do it. If you want to see if there's any questions for right now, and then we can get into the new attorneys.
Can I ask one more question that pertains to Baldwin or Rosie's legitimacy as private counsel? If their private counsel status would supersede the public defender status,
Yes.
I get that completely. But that doesn't negate the fact that like they still could be held responsible for the actions that took place under their watch while they were public defenders, correct? Because could they still be liable for sanctions or some other sort of disciplinary action from the leaks that took place from Baldwin's office?
Adam, what kind of work do you do generally?
I own a hair salon.
Huh?
I own a hair salon.
Should have been a lawyer. Okay, so
You didn't say that.
that's a really good question. Also, because from all appearances, one could look at what's happened last week as that she has the power and authority to remove court-appointed counsel. And they do to a certain extent. The Writ discussed some law about that, but that can be debated back and forth. But and what your question is asking, okay, she had the power to remove to court-appointed attorneys, or to get to that by giving them options. You know, she may have a completely different view of this Hobson's choice thing. But the power to remove a hired attorney is a whole nother deal. Judges do not have the power to remove hired counsel, even if they violate orders. The sanction for violating an order is contempt, pay a fine, go to jail, can report you to the bar. But unless pretty much, unless an attorney is impaired, coming to court drunk or other type of intoxication, where there's a real threat of harm to the public. And harm, what I mean by harm is that allowing this attorney to represent clients, paid clients, there's a serious risk that they're going to do harm to their clients, not physical harm, but legal harm. They're going to screw up their case. They're going to miss a court appearance. They're not going to be up to the task of a deposition or arguing a motion, those sorts of things. So it's a real good question. Okay, she was able to get them to see things that got them to withdraw from their case, withdraw from Alan's case. What's to prevent her from doing the exact same thing tomorrow? They file their notices of retained counsel appearance, that they're hired counsel, contract counsel. What's to prevent her from doing the exact same thing? Okay, everybody back in my chambers, right? That's the question. Hey, okay, here's my statement of, I'm going to read this to you. You either have to withdraw or we're going to go back in chamber or back in the open courtroom, and I'm going to read that and I'm going to remove you from the case. Except the problem is she doesn't have that hammer of removing like she does with court-appointed counsel.
Right.
Does that answer? I know where you were going with it, I think, but
I was curious.
That's an excellent question. I'm really glad you asked that, because I think a lot of people are asking that. And I just know, it's like anything. What Alexa does, what you do, there's certain things we just know because we deal with it all the time. And so we don't factor in that step consciously. And that is a step that I'm glad we discussed. There's a difference. And frankly, probably kind of hoping that does happen, because she did something that outlandish. The Supreme Court would probably step in.
Okay.
Thank you, Travis. Does anyone want to ask Travis anything on that in the chat before we move on to the three lawyers? And then we're gonna, like I said, then we're gonna get into the writ. And we got the record. Ooh, that was 240 pages.
Okay. All of which
then,
3 pages of it were new.
Right. You're talking about the
emails.
Yeah. Okay. Well, as people put up questions in there, but let's get into the lawyers here. There's the 3 lawyers, and again, Jesse and Cook being one of them. But anyways, Travis, go ahead if you want to move on to this part. Who do you want to talk about first?
Well, we can just go in whatever order, but on the writ that got filed today, the writ of Mandamus and Prohibition, that's actually one writ. It's just 2 sides of the same coin. We'll go through that when we go through the writ. There's 3 lawyers who have signed on to the brief. You have Jesse Cook there first. So did you want to talk to us about her, or I have a few notes? Either way.
Wait, no, go ahead. I'm just, you know what? I'm really just listening and learning, to be honest with you. I put the stuff together, and I know most people will want to listen to, what you have to say. I mean, you're a lawyer.
Well,
I'm not.
The main point on the 3 attorneys that signed this brief for the writ of Mandamus, these are all very substantial lawyers. These are not clowns. These are not, fringe. This is a very solid segment of the Indiana bar, and they handle 3 specific areas of the law, and they are all top tier lawyers in those areas. And so and that's really the main point I wanted to make. But so Kara there is 15 years of post-conviction appeal work, criminal appeal work. That's all she does, is post-conviction appeal work. Jesse Clark's been an attorney longer than I have, and leads the trial advocacy program at the University of Indiana Law School, and then also practices in private practice. But they don't let lawyers head up trial advocacy programs at law schools. That it's not one of those deals where if you can't do, you teach. If you can't teach, you go into administration. No, you got to really be a top trial attorney to be the head of a trial advocacy program. And then Maggie Smith is she's the prince of fucking darkness when it comes to public law. No, she is. And I mean, you read her bio, and her specialty is this area of law that requires clerks and judges, before they designate something as confidential or privileged or anything like that. That's her specialty. And she works for, a major law firm in Indianapolis. So I'm just really waiting to see who's got the cojones to call her a clown. You do not want to be on the other side of her when it comes to the issue of this law that we're going to cover in a minute. That's her specialty. It's one of the top 25 female attorneys in Indiana. I don't like the way they designate, but they typically do that. I suspect she's probably one of the top 25 attorneys in Indiana, period. She's a super lawyer. Her bio's online. People can read it. If you want to point out anything you read that you thought was appropriate, but it talks about that bio you found on her, that that is one of her main specialization areas, is this public record law that applies to clerk's offices and the courts. Go ahead.
No, well, first of all, I'm laughing because that was quite funny. And so then Charmaine said, where'd she say, you're Prince of fucking darkness. And then Charmaine said,
oh yeah, I screwed up. My apologies.
No, that's fine.
Princess the FD. Yeah, okay.
You are allowed to say that word as long as it's not like abused by YouTube. YouTube does allow it. But anyway, so then Charmaine says, change my mind, Travis for president. After she heard that one. Okay. Now Lewis is sending me something here. I'm not sure what it is. But anyways, let me go to our next one. So thank you for, you know what, again, you know, the synopsis, people can come back and watch the chat or go look up Maggie Smith and everybody themselves if they really want to learn more about each of those lawyers. But
the whole point is just that these are very solid, well-respected attorneys, and there's three of them. Each covers a particular area. And I realize, knowing the history, that in watching your channel in the past, it's hard for people that aren't familiar with the law or even familiar with the law. You hear all these different things about what are the merits of this Frank's motion, and then, you know, motions getting sealed, and then 100 and something motions all of a sudden getting unsealed, and you know, and people are talking, some channels are saying, oh, it's because what they're filing is inappropriate or doesn't have merit, or and so it's kind of hard to follow. But you know, these lawyers who filed this writ, and we got some stuff highlighted, and we'll see their names right here.
Well,
they're
Travis,
unquestionably, they know what they're doing, and what they file is, there's no question, it has merit. And and we're going to talk that we got a clear indication from the Supreme Court of Indiana, the Chief Justice, that this writ does have merit, and we'll go into why that is.
Okay,
Travis, I just saw an article. Thank you, Hudis, for saying that in the chat. WTHR 13 out of Indianapolis, they did have an article saying that that both Rosie and Baldwin did file their pro bono status.
Yes.
Okay. So someone should be able to go into my case, the lower court one, the murder case, not the writ case. And those should be the last two things filed. And maybe someone could do that for us while we're talking about this, see if they're in there. Because their filing system's the same filing system we have in Texas. You can file 24/7 because you file electronically.
It's Odyssey, right?
They contract. Yeah. Mm-hmm. And so you can, in federal court, same way, you can file 24/7. And then depending on what time it officially gets filed, if it's before midnight, you're good. If it's 12:01 a.m., it's the next day. And it pops up. So although sometimes a clerk has to okay it, so it may not be in there. Anyway, okay, I digress. Okay.
Just quickly, support what Steffa says. Can Gull be held accountable for having the clerk of court strike documents from the record?
Great question. And that's what we're going to go through on this writ. This writ of mandamus is to hold either the judge or the clerk accountable for removing something that shouldn't have been removed. And this is the way you hold a official. Any official can be the mayor, the clerk of the court, a judge. This is how you make them do something that they're legally required to do, or prevent them from doing something they're legally prohibited from doing that. So mandamus is you're asking the court to make a public official do their job, do something they're required to do. And then we're taught in law school, you plead the alternative because you don't want to get caught with your pants down. And so it's mandamus and prohibition. It's the other side of the same coin. Either require an official to do something or prohibit them from issuing an order, for example, removing documents. And it gets ultra technical, but it's two separate writs, but that's why it's mandamus and prohibition. But that's a great question, and glad it was asked. That's what this does. Now, there's also another avenue that you can take. Either a lawyer or a judge. Judge have to operate under rules of professional responsibility, ethics, just like lawyers do. And most states have a judicial ethics commission, and anybody can file a complaint with the Judicial Ethics Commission. However, those things, it's just like a bar complaint. They would have to be investigated, looked at, and then a hearing. It would be months and months. It doesn't do the defendant at the time any good. And so what lawyers do, if you have a judge that's not following the rules or the law, you file a writ of prohibition. Again, it's things that a judge by law has to do. So it doesn't apply to discretionary things like ruling on a Franks motion, like ruling on access to media motions, like ruling. Well, there's some examples in the motion that we'll get to that I've highlighted, but that's a very good question. This is part of accountability. And these lawyers on behalf of Richard Allen may be wrong, but it's getting to where this is going to hopefully restore some confidence into what is going on, that people will see that there is a process, because they're not, well, I hear this from this person, and I don't know where we're at. It's also confusing. Well, I'm glad this writ got filed, because people are going to see that there's a process. It's going to work its way through the process, and there will be an outcome. So, if we can scroll, there's the attorneys that we just talked about. Maggie Smith. My understanding, she's the primary author of this brief. That's the one that is the princess of FD that specializes in this particular area of law. There's Kara, and there is Jesse. I apologize for referring to them by their first name, being familiar. But look how they designate themselves as attorneys. Attorneys for, you pronounce that, relator.
Relator, yeah.
Richard Allen. So heard some speculation, do they represent him? That designation in Texas would mean that they got permission from Richard Allen to represent him and file this writ on his behalf. But there, I've heard that if you're an interested person, you can file this on behalf of the public. But they're asking for relief that is specific to Richard Allen in a way. My take on it is they're representing Richard Allen. Now, this writ is separate from the criminal case. It's in fact
Right.
a
This is civil,
civil
correct?
case. Yeah. Okay. So what do I have here?
Well, look, can I ask you a quick question? So, because I was going to ask you, because that was the first thing I thought about today when I saw these three names. I was like, and I looked them up, and they're very competent attorneys. But I was like, where did these ladies come from? Who hired them? How did they get, appointed to this case? And you answered part of that, I think, just now. At least speculatively. But I mean, in the filing with that 240-page document that they included in, there was an email exchange in there, which we'll talk about later, I think. But with direct correspondence between Judge Gull, Andrew Baldwin, Brad Rosie, and Nick McClelland. So presumably that email would have had to have come from one of those four parties.
There's no question.
So
you should have been a lawyer. Not that there's anything wrong with owning a hair business, but you should have been a lawyer. No, you're absolutely right. There's no.
Maybe next time.
They worked on this. They worked on this all weekend after they met with Baldwin and Rosie on Friday, at least at a minimum, either by Zoom or electronically.
Right. So you think Rosie and Baldwin probably are the ones that presumably orchestrated their involvement? Or
that I don't know. But they've been working together for at least 3 days, probably longer. So my speculation is that there's a national organization, NACDL, National Association of Criminal Defense Lawyers. They have a strike force of attorneys who volunteer to go anywhere in the country if an attorney is ethically pursuing the defense of a client and being attacked by a court. They have a team of lead pipe bearing lawyers that go in and will not back down to a federal judge, which is what mostly NACDL is about. They will not back down from a state court judge. They know what's proper argument. They know how to properly handle themselves. And, they are not afraid to go nose to nose with a lawyer. That's the NACDL strike force. The states I practice in all have a state criminal defense organization, and they all have a strike force. So in Texas, it's the Texas Association of Criminal Defense Attorneys, and they're an affiliate of the NACDL. They have a strike force, and I had to avail myself of them one time. Had this out of control judge, and so they came in there, and then I volunteered to be on it for 2 or 3 years to give back. But I suspect they're part of a strike force for this very thing, to come in on behalf of attorneys who are being unreasonably or unfairly treated by a judge. Because believe it or not, sometimes wearing that black robe goes to the heads of some of these people, over time. And they,
Judge Pouts.
They have to be brought back to reality. So that's what I'm thinking. However, could be anything. Could be some people raised some money and got them paid, but that's my speculation. Is they're part of a strike force. Somebody tapped them, and they came in, and that the defense bar, criminal defense bar, is pretty tight knit and very well organized, and that's what I'm thinking happened.
Thank you.
But
Yeah.
your guess is
I
as
was
good
kind
as
of wondering
mine.
that. Yeah. And I was kind of wondering that too. I was like, did they reach out to them, or did they, you know, did the attorneys reach out to them, or did these three attorneys, in a sense, reach out and go, look, you know?
Well, there's another possibility. Again, Attorney Hennessy been practicing for over
Yeah.
45 years. He retired. He's the one everyone will recall filed a brief on
Yeah.
behalf of Baldwin the day of the hearing. I mean, that guy is a rock solid trial attorney. He doesn't back down from anything. I'm sure he probably knows all of these attorneys. I wouldn't
Probably. Yeah.
I wouldn't be surprised at all if that afternoon, after he gave that quote to the reporter, they were coerced into withdrawing, or whatever it was that I read.
Yeah.
He was on the phone to some of these people. He was on the commission. There's a commission for the court-appointed attorneys process in Indiana, make sure it's run properly, that they have qualified attorneys. He was the chairman of that commission. There's representatives of prosecutor's office, defense attorneys, all kinds of people, public member. So he's very, very well connected. He knows all of the movers and shakers and criminal defense in the state of Indiana, and he could have reached out.
Quickly, just if you don't mind, Alexa, I know that you're quiet down there in the corner. Did you have anything that you wanted to ask Travis during?
No, I am just listening. Believe me, I'm listening, writing notes,
Okay.
and paying attention, so I know exactly what's going on.
I just don't want to leave you because I know you're down there.
No. Don't worry about me. I'm just listening and writing.
Whenever you want to peep in, just turn your mic back on. If there's any,
I will do so.
Okay, thank you. Okay. Okie dokie. Okay, so highlighted here. Well, CJK had said, let's just ask this. So that he said, if Baldwin and Rosie are back on the case, does Travis think that they will be sanctioned?
Sanction could either be by the state bar in a disciplinary process, and Rosie, no, from what I know, Baldwin, you have a responsibility to supervise. Might be some minor sanction. If they come in as private contracted counsel, court really doesn't have any means to sanction them, but she already did by taking them off as court-appointed counsel. But I guess she could go back and say, well, since you're back, I'm going to fine you X amount each for violating the order. Again, it's really thin on Rosie, but this writ in the background section that we're going to get to right now, it talks about a lot of this stuff. So if it was Judge Gull's intent to kind of, I'm going to talk about this at some point, but I think Judge Gull is doing what she sincerely believes is the right thing. And when we get to this, I do want to bring Alexa in and get her comments on this. But I just think maybe she just going about it the wrong way is what the deal is. She really wants a fair trial for the defendant, wants to protect the family, or protect's the wrong word. I can't think of it. Adam will think of it in a second, I know. But he's trying to respect the family and to keep everybody happy and but in doing so may unintentionally skirt some of these laws. That's kind of my impression on it right now. But when we get to that, I want to get Alexa's take on that. So this writ, again, it was filed by these very competent lawyers, and it's to get the judge and or the clerk to comply with some certain laws, which, if it's granted, is good for Sonny, it's good for other people, it's good for the media, but it's good for justice. And we'll talk about that in a minute. So if we scroll down.
While
so
we still have this on the screen, can I really quickly, as an attorney, I'm sure you are familiar with the importance of language and, how it's used in writing up a document. Because I know from just my personal opinion, when, they're talking about like the 118 document file that they're saying is not easily accessible to the public because it was in a link to a website where you could access all of those files. And so I found some of the language to be, in my opinion, a little persuasive towards the intent they have, as far as they want it to sound like, this is being hidden from the public, when, I felt like it was very highly publicized that, anyone that wants to access this 118 different documents, follow this link. It described in court, and so I just felt like some of the language is very, like, I feel like I've never had any problem finding public access to the things that are publicly accessible.
Yeah. Well, it's funny you should say that, Adam, because when I read the letter and her order about that, and as I read through it, I was going to ask you and Sonny and Alexa, she talked about she'd conferred with the clerk and that to get these 118 documents back into the system,
Right.
What was going to create, I don't want to say manpower, human resource pressure. And I'm thinking, well, if I was a reviewing court, that aspect of it, I could see that that's reasonable. And I was going to ask you what you all felt, but I don't disagree with that. But no, this thing's written to be persuasive, and you don't have to include both sides of the argument. You can just include yours, and what she's argued on that particular aspect is a very technical thing. I didn't check her sources or what the actual statutes meant, but that's something that when the Indiana Supreme Court actually rules on this, could say, yes, technically it's supposed to be in the, PCS system, CCS system.
Yeah.
CCS. And, but in her order, which was publicized across numerous clerk's offices, they say the file names are so long that it won't convert. I didn't have any problem with it, but but of course that's not the only thing they're complaining about. And the other things that they're complaining about, I think they do have some merit. But no, I agree with you 100%. When I was reading that, I'm kind of like, well, that's going to be one of the things I'm going to ask other people on the panel what they think about it. And I think some of the judges looking at this might agree with you on that point. Absolutely. And
Right.
there's no, you can word stuff. You can word things that are from your point of view. You just can't word them to the point of that they become a falsehood. I don't have any criticism of the way she phrased it, but
Right, and I get that. I'm not criticizing her. I'm just
words and language are tools, and people come to me, young people,
and they're powerful.
Say, I'm interested in getting into law. What should I major in pre-law? And political science? I'm like, no. Major in English. And if you can get a journalism minor, do that. English and journalism. That's and I struggle with it every day, and I'm just enamored with those lawyers that have the gift of language, and one of the best that people can see, and I don't care what side of the fence you're on about things, but Dean Strang is one of the most eloquent speakers in the law that I've ever seen, and I've seen some of the best. And Dean Strang has a mighty command of the English language. Incredible.
I don't. I definitely don't. Just to ask you, you guys talking about the Adam? Are you guys talking about those 100 and the PDF files?
Yeah. I was just referring to. Remember when John, we were waiting for John to get that website finished and uploaded, because I believe it was Murder Sheet that filed that thing about having things filed properly, which that has been an issue in this case, absolutely. And and Judge Dole, upon hearing that argument, immediately was like, yes, these things should be released publicly, and created that website that would have all of the documents, and the only documents that were withheld from that at the time, I was told, were that pertain to his health and mental health, which those would be a HIPAA violation anyway. So to be public,
you're talking about these ones, right? All these documents.
They're listed in the motion. We'll get to it. It's on page 5 of the motion. She lists them all.
Let me go back. Yeah, I was gonna say. Okay, so let me go back over. Stop screen. Hold on. Stop screen.
Go back to where you were on page 3. And,
sure. Just gotta get myself organized for a second again here. Okay, so we're on let me just pull it up. Brief and support.
Section 1A, background, page 3 of 22.
Okay.
All right. So this heading is background. So what the lawyers on behalf of Richard Allen are and there, we see right there at the top. Adam, can you go back up just a little bit? Adam, can you read, this case involves, can you just read that paragraph up to the public?
Yeah, sure. It says, this case involves one of the most high-profile matters in Indiana history. On April 5th, 2020.
Okay. Sorry, I apologize. I just said amen.
On April 5th, 2023, defendant, how did you pronounce that word? Relator? Relator.
Perfect.
Relator. Richard Allen filed an emergency motion to modify safekeeping order, exhibits, and a proposed order, marking everything as public documents.
Okay, so they're talking on behalf of the defendant. I think they represent Allen, but so they're given the history so that court will have a context, and context is everything in the law. If you just tell them what happened last week, they're not going to get the full story. Now, the other side may be wanting the Supreme Court to focus only on what happened last week. Every issue is different. Sometimes you want the court to know the backstory. Other times, no. I just want the court to focus on what happened on that specific day at that specific time. You do the same thing with juries too. That you don't want the jury maybe to know the whole life story of your client and what a son of a bitch he is, and you just want him to focus on, what did he do in that bar room that night?
Right.
So
kind of like Alec Murdaugh and the and how they tried to keep all the financial stuff out of the murder trial.
Yes, very excellent example. Once again, Adam, thank you for that. Absolutely. And the state wants you to know what a son of a bitch is, right? Yeah, of course. They're going back to this first example, April of 23, getting stuff unsealed and whatnot. We don't need to go scroll down just a little bit to where, okay, stop sua sponte, Latin. I just wanted people to know that means, scroll back up to those blue letters. Sua sponte just means court's own motion. Court has taken notice of an issue on its own motion without prompting or suggestion from either party. That's all that means. In case anybody was wondering, I keep highlighting the record. At the time, I didn't have it. And I sent an email to Sunny and I said, boy, oh boy, it should be nice if we had that record. And then 2 minutes later, she sends me a 240-page document, said, why didn't you say so? And so we'll look at some of that stuff. Anyway, so here's the law that Ms. Prince of FD, Maggie Smith, knows better than anybody, is access to court records, ACR form identifying the specific Rule 5 grounds upon which exclusion is based. And that's important to know the grounds. And, they didn't do that on the 100 and some odd documents, but they claim, it's ongoing. There are still documents that are designated confidential, and the law requires that somebody files something pursuant to this rule that gives the grounds and that it meets one of the statutory requirements. And then I have it in the top of the next page, if you'll scroll down, and we'll figure out natural time to take breaks. And Alexa, it's worrying me you're so quiet. If you think of anything, just please unmute yourself and be happy to hear. So the grounds are important so that the media public can determine if judges' decision reasoning is sound. And contrary to what we all might believe, judges aren't perfect. They don't always have sound decisioning or reasoning. And that's throughout the criminal justice process. It's any human endeavor. The weakest link is going to be the humans that are involved. And that with any system, I don't care if it's sending rockets to the moon or trying to secure a fair trial for somebody. So, you have humans involved in prosecuting, defending, judging, analysis, forensics. And I'm sure Alexa can talk about this, that while we strive to ensure that people in our areas of expertise are meeting the requirements, it's impossible in any human endeavor to weed out human error 100%. And the whole reason why this stuff is public is so that the public and the media can report on it. But, in Britain, it's called the Fourth Estate, started by a philosopher, pretty smart guy in the 1700s, Edmund Burke. The media has to be in court proceedings, and they're deemed the Fourth Estate. As a matter of fact, when you go on tours of things like the Old Bailey, there's a area specifically for the media. And, it's very, very important. Anyway, so they reference the gag order, and they point out that the gag order was extra court statements made out of court by the family, the prosecutor, or the defense. And they point out the gag order did not apply to pleadings. And I put that in that red box. The trial court then allowed the parties to agree to exclude the entirety of certain records from public access, even though both actions are prohibited by the access to court rules. Now, this was interesting to me, is that, and again, I explained Latin. Id for idiom is the short form used to refer to immediately preceding citation. So you'll see up above, it's id, and then it's to the gag order. Anyway, we frequently, especially in family law cases, I don't do family law, but I know that the attorneys will agree that they'll keep certain documents private with respect to their children, for example, and so on and so forth. And in federal court, you can ask the judge to enter a protective order, and either side can designate documents confidential, and they'll remain confidential. And then if you want to attach them to a motion and file them with the court, you do so under seal. And most of the time you work that out, whether something really should be confidential or not. But Indiana, the legislature, is so serious about these rules of confidentiality. And most legislators are attorneys or were attorneys, and they know how this stuff goes on. And, they put in the commentary to the rule that attorneys cannot agree to sidestep the rule. The interest of the public and the media trumps, I need a better word for that, Adam, supersedes what the attorneys may try and do to subvert that rule. Okay, so that's that.
Yeah, thank you for explaining that, because I was wondering about that myself when I saw that.
And then they talk about, again, the rules that she's a total expert on, that what the alternatives are, and we don't need to go into that. Let's go down to the next page.
Past, like, that further down here?
Yeah, let's see what I got there. Okay, can you read that in yellow, Adam, please, that yellow highlight?
Yeah, it says the trial court did not order the clerk to make the documents on the CCS public, something that clerks do all the time, which would have allowed the public to identify the filings they wanted.
So this is talking about, the things that you were saying that, I don't know how, much of a violation this is. And also talking about that they may not open, and scroll down, and there's the screenshot of some of the things that were dumped at one time, and more problematic. The file names have no clear identifying information to let someone
Those
know
are
what the
a pain.
document actually is. And I thought, just double click the damn thing.
Yeah, but there were
Then
so
you'll know.
darn many.
Oh,
That
I
was the
know.
thing.
Okay. All right. Maybe she has a valid point and Adam's wrong. Anyway, no, I know what you're saying. In the CCS system, you know exactly what the document is, right? I mean, it
I mean,
tells them, but here you don't know. And so, yeah, Adam, they're trying to point out from their perspective why they say on the next page, go down. Go ahead.
yeah. Oh, no, that's fine. Go ahead.
Right there. Many of the file names are so long they cannot be extracted, which makes the documents inaccessible. Like I said, I didn't have any problem.
I didn't. Yeah.
Well,
I do want to preemptively say that. I mean, I think that, making all this more accessible is great. I mean, I get that it's a lot of work for the court, but I don't dispute or argue that, that this all shouldn't be publicly accessible. I mean, I do think that, that the defense memorandum that was 136 pages, if they're going to make that public again, I do think they should probably redact it, because I think out of respect for people that they publicly accuse of murder in it, they should redact some of those names, because those claims are unsubstantiated.
Yeah.
And I think that's why it was been made confidential.
Yeah. So there's no question, and to your point, Adam, what we've seen so far in this background would never be filed standing on its own. It just doesn't rise to enough of a level that you'd file a writ. And they're just kind of setting the stage that, there's a history of this with this court, and that's why we're asking you to step in now. Now the real interesting thing, so they point out in the red underline there, the actual CCS in this case. CCS again is the court clerk system that's really good in Indiana, that shows what all the documents are, all the hearings, still has every one of the 118 documents excluded from public access. But as you pointed out, her order explained that, and they don't mention. However, they do attach the full order in the records. So it's there. Anybody can point to it and say, well, the court explained why they didn't order the clerk to put everything into CCS. And again, I think some of the judges may agree with you. It's not a violation of the spirit of the law. Her order fulfills the spirit of the law, that the public has access in some way. It may not technically be perfect, like how Maggie and the other attorneys are arguing. It may not technically be perfect, but hey, she's trying to comport with the spirit of the law, that if you just look a little bit, put a little effort, you can get to those 118 documents. But did you talk about, in addition to the items the trial court allowed, I'm reading that next highlighted, there are two more documents that remain excluded, are not on the zip drive, do not have an ACR form, and for which an ACR Rule 6 hearing has never been held. Go back up. Paragraph starts in addition. Okay, right there. One, a June 20th, 2023 filing by the Carroll County Sheriff. And number two, a July 5, 2023 letter from a DOC, Department of Corrections inmate. Are y'all familiar with those two documents? Or that
Sorry.
murder sheet to the attorney? That's a duo. One's an attorney, Green something.
Anya
Yeah,
and
Green. Yeah,
Anya.
They
Anya
filed a motion. Yeah, he filed a motion with the judge to say, look, it's improper for you to keep this stuff, and it's in the record document, the 240-page document. Copy that motion's in there saying, hey, it's improper for you to keep this stuff secret or not available unless you file an ACR form and have an ACR Rule 6 hearing. And we'll see, I highlighted the date that was filed, and to this day, there's been no ruling on it. And then here, the next part, more recently on September 25th, 2023, the state filed a motion to exclude all future filings from public access. That's just unheard of. The only thing that's even remotely close to that is FISA court, where national security, I mean, it was a special court set up to try and defeat terrorists. And even those records become public after 25 years or something, but never in any criminal case have I seen a DA try and that all future filings be pulled from public access unless the court conducts an in-camera review. That just means private, in their chambers review of each filing. And the
Can I
state,
point out really quickly? You know, the filing that they're talking about, the motion that the state filed. I mean, I don't think it was ruled on, but it was in direct response to the defense filing that public 136-page memorandum for the support of their Franks motion. And then the next day they like doubled down and filed more things, like publicly. And so, I mean, I believe that this was in a direct response to the fact that, they felt like the defense was trying to skirt the gag order by putting these things that didn't even pertain to a Franks hearing in a public filing. Because I think a lot of people have said, that 136-page memorandum, 13 pages of it may have pertained to actual pertinent information for a Franks hearing, and the rest was just, a narrative that they wanted in the public.
And with everybody's names and everything was there. Like everything was in there.
Yeah.
So I didn't mean to interrupt you. I'm sorry. I know that.
I'm sure that's what people said. I'm sure that, but it's inappropriate. There's other ways to handle that. You file a motion to seal the Franks motion. Now, I mean, the state can ask for it, but one of the other complaints I keep hearing is that she's not ruling on stuff. Just letting it hang out there. They're, pointing out that, we have this stuff going on. She's sealing stuff. She mentioned somebody, doesn't say her, somebody from the court system sealed this stuff. Don't know who. That's problematic. That stuff gets sealed, these 118 documents, and there's no court order. There's nothing from the clerk. Who's sealing this stuff? This stuff just doesn't go on in courts. I mean,
right.
Stuff goes on, but people are accountable for it. They say, I'm sealing everything. And then until we figure out where the leak is. I've seen that, but like Alexa asked me the other day, have I ever seen anything like this? And not all together in one case, but point well taken, Adam. So that's why the state files it. What I'm more concerned at is at a deeper level. Why would the state even think that a court would consider that? I mean, you don't exclude motions. And what they're pointing out, these attorneys in this writ, is that documents in Indiana, just like every other state, that get filed with the clerk, there's a presumption they should be public. The presumption is that they are public and should be accessible to everyone. If you don't think they should be public, you have the burden to come forward and indicate what different categories of confidentiality apply.
Right. Which can I ask you a question really quickly? So typically, like my understanding is in Indiana that the clerk usually determines the basis of how something is filed on sometimes the color of paper that they receive it on. Am I inaccurate on that? Like there's something with like if something's public, it'll be filed with ink on green paper, or is that completely something you've never heard of?
You cut out a little bit, but so the way like it works in federal court is if you have something that so the parties exchange information, first of all.
Right.
Here's my stack of documents, Adam, that I'm providing you in response to your request, and then you provide me with a stack of documents. The documents I give you, I can literally take a red stamp and stamp confidential, which
Right.
means you cannot let out of your office because there's a court order, a standard order. And then it's like, okay, well, I do want to use those documents that you've stamped confidential. So what I need to do is I file my motion, and it says attached here to as Exhibit A is documents, whatever, which have been designated confidential by the other side and are being submitted under seal. And then there's a mechanism that's how it's normally done. The attorneys are under this order, and we know not to violate it. And so the clerk needs to do nothing. It's all set up. But every once in a while, no matter how careful we are, and you're dealing with hundreds, thousands, sometimes hundreds of thousands of documents, you end up filing something and something gets through that shouldn't have. And we have to file what's called a motion to remove the document. Clerks really aren't, despite what we think, they're not really reading the documents to find out, okay, is this proper under civil rule? They just file whatever they're given. And they look at format. There's a 50-page length maximum, and it's 62-page. They'll file it received. They'll get further guidance on it to see if it should be filed or not, and they'll just mark it received. But clerks really don't do much substantive decisions. They're just looking at, is it on 8.5 by 11 paper? Is it white? Is it typewritten or handwritten by an inmate?
Can I ask really quickly? If a clerk, if a clerk files something, or let's say defense team files something publicly, and upon reviewing that after it's been filed publicly, the court deems that there's information in that is a violation of someone's rights, leaves the court up for libel because they've, let's say, accused someone of murder that hasn't been implicated, in this particular court case. Is it within the court's right then to seal that document?
Sua sponte.
If it hadn't been redacted at all.
Yes, it is. The court can do it sua sponte if they follow the procedure and file the form and do that according to the writ. But absolutely they can, and they can admonish counsel, hey, that clearly falls within Rule 5B of the ACR, access to court records, I think is what that stood for. That's in clear violation. Please don't do that again in the future. Take the appropriate procedures to file that under seal or whatever they call it there. But no, absolutely. But they're complaining about something else, and then you bring up something, okay, that there's documents that get filed that accuse other people that haven't been formally accused, or so on and so forth. That's not a reason to seal a document. So every state has a third-party suspect rule, and if part of your defense is Saudi, some other dude did it, SODDI.
Yeah.
So if you have a Saudi defense, well, most states have a thing saying you can't just point to some unknown, unidentified third-party suspect. You have to come forward with their opportunity, their motive, and what their direct connection to the crime is. Because anybody could say, oh, well, that was, somebody else. And
right.
It's got to be plausible. That's the public policy for that rule. And then, so you have to come forward and name specific people. And that Joe Smith, we're going to be arguing at trial. Part of the defense is that Joe Smith could have been responsible for this. Here's his motive. Here's his opportunity. Here's his direct connection. And then person 2, person 3, person 4. Those documents aren't sealed. I mean, they're wide open for the whole entire world. And so this goes back, and let's just talk about it now. I think the court is doing its sincere best to balance the rights and ensuring a fair trial for the defendant with keeping a lid on things. But the problem is those two things are inconsistent. And that's what they're pointing out, that attorneys can't agree by stipulation to avoid the ACR rules. That if a judge is going to sua sponte deem records as sensitive, confidential, whatever you want to call it, they need to fill out a form. This may be the way she's used to doing it in her court, in her little corner of the world, but it's not complying with the law. Others have seen her and excoriated her and said all kinds of bad things. Others have looked at it and said what she's doing is exactly right. And I'd like to think she's trying to do her best, but by trying, she fancies herself an innovator. If you go on a website, it gives her bio, and she talks about that she's an innovator, and she is. She started this program for drug offenders. And look, in rural Indiana, like rural anywhere else, with Anglo Caucasian people like me, meth is a huge problem. It's a huge problem in rural Texas, and it's a huge problem in rural anywhere. And meth is the scourge. It's just different than any other kind of drug, especially when you get to the IV level. It changes your brain composition, and AA and NA and all the other things, they just don't work. And so she came up with a system, a drug court, from what I understand, and it's helped hundreds, if not over 1,000 people by now, and that's innovative. That's bringing in a program, but judges are not allowed to be innovative about constitutional rights. You can't say, well, in this case, just for kicks, I think I'm going to force the defendant to testify against himself. Just can't do that. And, there's long sound rational reasoning why courts are open to the public, including pretrial hearings. You have a constitutional right to it as a criminal defendant, to a public hearing, and that public trial and pretrial hearings be public. And so I'm a bit concerned about how things are. And then when you put it together with the emails, there's a lot of behind the scenes going on by emails that, frankly, I was shocked about. But again, maybe, she sees it from her perspective and thought, well, I'm going to give it easy. I like these lawyers. I think they really worked super hard for Mr. Allen. I don't want to embarrass them in front of a national TV audience with these things, but I'm sorry, it's still not up to the standard of the way it should have been done. They should have been given notice, and what that notice is typically called in every court in the country is a order to show cause. And you're given a document. The court has set a hearing on that the defense counsel be disqualified or ordered to show cause why they shouldn't be. Now, you can be super detailed in that motion or be very general, and that's how you handle it. You just file very general. Some things have come to the court's attention, and you handle it that way. But some of this stuff is problematic. I don't think it's as serious as some think, and I think this thing can be put back on course. But I'd like all of your comments on that. What you think?
Travis, I do have a couple questions that I want to get to, if you don't mind. This one, Cold Truth, she says, can this hearing legally take place tomorrow in light of the Supreme Court decision to have the motion to continue submitted by Rozzi to be added back to the court docket for Allen's cause number? So,
okay, wait a minute. So, is there another document? I'm not aware of this. So there must have been something else that came in.
No, this was filed last week, the motion to continue. It was basically just a motion to continue the hearing on the 31st.
Yeah.
Until the other things.
I've seen the motion that Rozzi filed, and he said it should be continued in light of these other things that need to get squared away. But this says in light of the Supreme Court decision to have.
Don't they have the removal of Judge? Remember that Rosie filed for the higher court to
Right.
get in to look at this and see if Judge Gold has to be removed from the case?
Well, he didn't file that with the Supreme Court. He filed
No.
it with.
This says
Sorry?
Supreme Court decision. So what he would have filed
second, let me
is
see.
something that said, and this says Supreme Court decision to have the motion to continue submitted by Rozzi be added back to the court docket.
So
I'm not aware of a Supreme Court decision.
Is he talking about the order that was issued about the 9th of November?
Yeah, let me hold on. Let me just go to that for a second here.
Right. Yeah. I think she's referring to the order that was asking for anyone with other information to be submitted by the 9th of November.
So hold on. So let me.
Okay. This doesn't have anything to do with the motion for continuance.
Hold on.
But we were going to talk about this anyway.
Well, let me just hold on. Let me pull up the second page. But the second page, I don't know why it's not on here. But let me just, I'm going to bring it into the documents. Give me a second. I don't have time to sit there and go try to make it into a PDF. It's just 2 pages here. Let's see. So this is
I'm Miranda Lee. The other female is Alexa. I know she's been quiet tonight, but she is a criminal profiler, graphologist, and body language expert.
I think this is too blurry because when they're getting sent to me, they're getting sent to me from phones. So it's Adam. Do you have this to read it?
Yeah, I have it.
Okay. Okay.
I can read the so this is starting off. This is. Do you want to read the first page first or this one?
Just read the first page first because we were going to talk about it anyway.
Okay. The first page is the in the Indiana Supreme Court. This is an order. The realtor Richard Allen by counsel has filed a verified petition for a writ of Mandamus and Prohibition, seeking relief under the rules. Mandamus, thank you. Seeking relief under the rules governing original actions. Any briefs opposing issuance of the writ of any supplemental records must be filed directly with the clerk of the Supreme Court on or before Thursday, November 9th, 2023. Any supplemental records must be submitted in the same format required for the record under the original action code rule 3C and G. Once briefing is completed, the court will take the matter under advisement. Done at Indianapolis, Indiana on 10/30/2023. All right. And then the second page reads permanent writ of, say it one more time for me. Mandamus, man, and then woman, dame, and then us. Man, dame, us. Mandamus.
Thanks, Melissa.
Mandamus. The original actions come before the Supreme Court on the application of the realtor from a writ of mandamus and prohibition against the respondents. After examining the application and preliminary response and being advised in the premises, the court grants the application. It is therefore ordered the respondents, the Carroll Circuit Court, and the Honorable Francis Seagull, the special judge thereof, must reinstate the following court records as publicly accessible.
Let me have you pause. I know what this is. Let me have you pause. Scroll down to the bottom where the judge's signature should be.
It's not there.
Okay. This is a proposed order.
That's pretty sure.
Thought. And a proposed order is very common. You fill out what you hope the court's going to rule, and then the judge takes that and goes, well, I don't agree with that, scratches that out, and then so that's a proposed order. So to answer your was it cold truths question, it's not an official order yet, so it doesn't have any impact whatsoever. And then, but
Is
I'm
it
glad you
separate
did
than the
ask
first
that
page?
question. It's an excellent question.
Because the first page had a judge's
What?
signature. The first page that I read, the order had a judge's signature.
Okay, let's go back to that. Let me see that.
Sorry.
It's okay.
Sonny, can you go back to the last picture? Oh, Sonny may have.
Well, we're waiting for Sonny to come back. So the other part of this is that apparently one of your viewers posted, I saw that one of the TV outlets was reporting that officially that the two attorneys, Baldwin and Rozzi, have appeared as attorneys in the case again. And so that's going to supersede anything about the hearing tomorrow. Okay, this order, yes. Okay, so what this order is, and that's one of the documents we were going to go over, that is officially filed by the Supreme Court and has the signature of Loretta Rush, Chief Justice of Indiana.
So
that was
is
filed.
That not connected? Is that not connected to the other document that it's attached with?
No, this is an order. This is why we know that the writ we've been going through has substance, because they've ordered, says the relator, Richard Allen. Are you able to read that for us? Why don't you just read the order if you can?
Oh, I read it. I read it just a minute ago.
Out loud, you did?
Yeah.
Oh, you did?
I did.
Yeah, he just did. He read it prior. Yeah, it's okay. Do you want us to read it
Are
again?
you sure?
Yeah, 100%.
Yeah, I'll read it again.
I'm losing it. So basically, anybody who wants to oppose this writ has got to file something by November 9th. If the court didn't think there was any substance or merit to the writ, a mandamus, they would have just dismissed it. Happens all the time. People in prison send a writ of mandamus to the Indiana Supreme Court, and the Chief Justice dismisses it out of hand because it doesn't have any merit. But this, they're saying, if you want to oppose, you better file your brief and any records with the clerk before Thursday, November 9th. And so the Indiana Supreme Court is going to rule on this, what we call on the merits. They may not have an oral argument. They may just issue a written decision. But on the merits means they're going to consider all the arguments and make a decision, which is completely separate from anything involving the motion for continuance, anything in the criminal case that's being handled by Judge Cole. It's completely separate. One doesn't have anything to do with the other. Now, if they had asked that the criminal case be stayed, which they didn't, and the court ordered on that, and yeah, there would be a connection. But judge
But can I ask you a question? Is that different from the motion to disqualify the judge?
So,
honey, you have it on. Okay, you have it on. Okay.
So the motion to disqualify that I read, filed by Rozzi the same day, filed as notice of continuing representation. And I heard y'all talking about this the last episode about the motion to disqualify.
Yeah.
I thought somebody raised somewhere that normally the motion to disqualify gets assigned to a different judge. The judge that you're seeking to disqualify doesn't hear it. It varies jurisdiction to jurisdiction, but most of the time, what they call the regional presiding judge assigns a judge that will hear the motion to disqualify. They're usually brought in from a different jurisdiction. So it doesn't put, one judge that you see every day deciding something about another judge. And so, this stuff is thought out. But in this situation, the Judge Gull removed that. She struck that document from the record and ordered it be removed by the clerk. If they come back in, which it appears that they are, that they're reporting, it's confirmed that they're coming back in as contracted private counsel, I think is what the term Adam read to us a bit ago, not public defender counsel, that they're coming in. She can't prevent that. And he could renew that motion and say, okay, Judge, I'm back in. We're back. And, oh, by the way, that motion you said I couldn't file because I had withdrawn. I'm renewing that. And here's a new one I'm filing right now. And we want to disqualify.
So someone said to me that if it's true that in order for it to be official, that both Rosie and Baldwin would have to seek leave from Gull to enter their appearances.
No.
And in theory,
bullshit.
She could deny that. Is that not true?
Bullshit. You just file notice of appearance of counsel. I'm hired.
Okay, thank you.
Every system of public defender, that's why they're doing it. It's out of her hands. She has the right to control court-appointed public defender counsel and make sure that a defendant, because if the state appoints somebody who's ineffective, it has to be retried.
Right.
But if you hire private counsel, you're not given the same deference that when you hire and pay for counsel, you're not given the same deference. But no, you just file notice of appearance. And, there's the component, rural Indiana, without getting into politics, but rural Indiana, they're of the same kind of political ideology as rural Texas. And they're typically very fiscally conservative. And I don't know if you guys caught it in some of those motions, the motion to disqualify, the notice of continued representation. Rosie, who represents school districts, several, is the general counsel for several school districts, mentions that it would be, fiscally stupid, paraphrasing, but he's got a better command of the English language than I do. He said it's going to be super expensive to bring in new attorneys at $167 an hour, or whatever the rate is. And, it's going to cost hundreds of thousands of dollars to get new attorneys up to speed. And, they're aware of this. And so there's a fiscal component that gets raised, and private counsel coming in that means the state's no longer on the hook financially. They don't have to pay another attorney to spend 1,000 hours to get up to speed at $167 an hour. $167,000 times 2 is $44,000. They've already had to impose a new assessment. They went in and asked, the county treasurer did, for an additional, it's either $1 million or $2 million to cover the costs of trial. That was for a trial in January. Most of that was for salaries and people, which I assume was also the attorney's fees. This is breaking the back of that county. And at some point, property owners are gonna start to assert themselves about how she's handling this. And if they're what I picture a typical rural Midwesterner to be, as much as they want justice to occur, they want it to happen in a fiscally sound manner. Are any of you, I know Sonny isn't, anybody in the Indiana Midwest can confirm that?
Yeah, there's a.
I know the assessment happened. What are we looking at here?
Oh, well.
Alexa, did that answer the question?
Yes, it did. Thank you.
Well, I don't know if I have the right file open, but a lot of the chat, they're waiting for you to talk about the emails that I keep seeing.
Of course they are.
So, yeah.
Okay, that's what we're gonna finish with. So let's just pull up.
Well,
if you want to go to the 240 page document, I can tell you what page it's on real quick.
That's this one. Yeah. That's this one.
It's that one. Okay, and you found it. All right. And what of 240 is that on?
Oh, this is like 191 or something like that. 191. Yeah.
Okay.
Yeah. So this is
pull that up.
191 on there. And I'm not sure if you wanted to touch on the Ramirez after this, or if you wanted to touch on that.
No, I think it's a good time. Have Alexa introduce us to that case, and then we'll go into those emails.
I want to do that.
Alexa found it.
And give me 1 second. So basically, we're going to talk about I got this morning, I got a somebody was talking about this case, and I got interested, and I started reading about the Juventino v. Ramirez, which basically states. So hold on, I made a couple notes. Where are my notes?
Why can't I find that?
So basically, it said that Ramirez was a defendant that went in front of Judge Gohl. They said that it said defendant entitled to a fair trial. Ramirez proceedings were violated. Basically, the defense was not getting the information. They filed a continuance. The judge didn't grant it. Information. They did an interview of a new witness, like the day before the trial. The defense didn't get it, and basically, it ended up being that they had to do a. They requested for a new. Hold on a second. For a defendant established prejudice resulting from Judge Gohl's denial of his continuance request. Judge Gohl abused her discretion by denying the defendant's continuance request, and his conviction was reversed and remanded for a new trial. So this was kind of interesting to read because it's kind of on the same footsteps as this one, in my opinion. Obviously, you're a lawyer, you know more.
Criminal allegations were
Alexa.
Sorry.
I think Travis is talking to you still.
Sorry, I didn't hear. Hello?
Travis, what'd you say?
Sorry.
Can you hear me okay, or am I lagging again?
Yeah, now I can hear you. Sorry.
You're lagging a bit, but yeah. Did you? Sorry.
Okay.
Were you saying something to Alexa?
Yeah. So, but
Oh,
don't want to interrupt
you got
her.
a
Is she done?
yeah. You got a bad lag all of a sudden again. Can you pop in and pop out and then pop back in?
Yep.
Yeah, because you try to straighten out that lag a bit.
I think the last one he was
Okay, I'll be
okay.
right back.
I think he sounds okay now.
And can you pull up that
No.
case that I sent it to you?
The Ramirez one? I know. I was trying to find it. I'm like, where did it go? It was in my documents.
Do you have it, or you want me to send it again?
Alexa, just quickly send it to me again.
Sure.
Did you send it through Messenger? I mean, I got it
Yes,
in an
I
email
did.
somewhere, but
Yes, I did. You should have it.
yeah, I know I have it.
And I'll send it to you. I have it like right here.
My email is just so.
I know you got so much. So yeah, I have it right here.
Well,
I'll
I
read
had it. And I don't know where it went to, but it would probably just be easier. I know I have it. Emails.
Okay, you should have it.
Okay, let me take a boo here. Okay, let me do it. Okay, maybe I have it open already somewhere.
Probably you do.
Maybe I don't know. But anyways, I'll just pop it open again here. Alexa. Maybe yeah. I don't know. Anyways. Okay. Let me just present, stop screen, share. Whoops. Adam, can you add Travis back? Okay, I'll do it. Let's see. Travis, are you there?
I'm here. Can you hear me?
Yeah, I can hear you. There we go. Okay, so this is the case. Where's the
Okay. Blow that up so we can see the file date.
I was gonna say where's the blow up option? Here it is, I think. There it is.
That
Okay.
was last year, 2021, I think, 2022.
Yes.
Okay, where do you want me to go on it?
That blue circle, so filed to the top where it's that blue circle where it says filed and the date. Let's see. Okay.
April 27th, 2022.
Filed.
Yeah. Filed on April 27th of 2022.
What does it say? April?
Sorry.
Okay. And then, so scroll down. So it's Mr. Ramirez, appellant in the Indiana Supreme Court
Where am I
versus the
scrolling?
state of
Sorry.
Indiana, which means typically that he lost at the Court of Appeals level and petitioned the Indiana Supreme Court. They call it a motion to transfer. That simply means you want the Indiana Supreme Court to take a look at it because the Court of Appeals went against you. And let's see, they argued it October of 21, decided April 22. Scroll down just a little bit, half a page, scroll down, stop. That was a full page. Go back up. I want people to see who the judge was. There we go.
Friends, yeah.
The Honorable Francis Siegel, judge. And hopefully Alexa got to explain, it's one of those horrible cases, a father allegedly abusing his daughter by rubbing private areas. Initially, the allegation was on the outside of clothing. And Alexa is exactly right. The other side asked over and over again for access to a video of the victim. They were fine with limitations on keeping the video private, but there was a local rule that said you had to go to the prosecutor's office to view the video of the victim. And the court held that the local rule was unconstitutional, number one, and then number two, that Judge Gold's continued denial of at least even a one-day continuance. Because what happened is, one day before trial, the DA called up the defense attorney and said, here's information. We brought in the victim and her mom. I've talked to her. Here's what they had to say. And essentially it was several new theories, including one that he had touched her with her hand under her clothing, which is in most states a whole level of more serious offenses. And the attorney said, hey, this alters my entire defense. I need a continuance. She said, no. Long story short, he was convicted, and then it was appealed, and the Court of Criminal Appeals said, no, the conviction stands. And then they appealed to the Indiana Supreme Court, and that's a discretionary appeal. They don't have to take it. They look at it and say, yeah, this is important enough issues, we're going to take it up. And then the opinion, Justice Rush and four other justices, it was a 5-0 decision, not any question about it whatsoever, reversed and, as Alexa said, ordered a new trial. This, I just thought, was a good example if, like, people, no matter on what side of the issue you're on with respect to Mr. Allen or the state or the defense attorneys in this case, if you want justice done, especially if you want justice for those two girls, and I sincerely apologize, I'm terrible with names. I know one's last name is Abby and Libby. It is not inconsistent, if you want justice for them, to want good, competent attorneys and a fair and legal judge presiding over the trial, because this is a perfect example of what happens. Now they got to retry it. But that young lady, it's not easy for a victim of that type of thing to testify against her own father. I can't remember if it was a stepfather or a father, but it doesn't matter. It's a very traumatic event for a victim. And I'm sure Alexa can talk about that much better than I can. But now, because of a refusal to see that fundamental fairness required at least a one-day continuance. That nope, we're going to just do this my way. A year ago, a victim's going to have to, she may already have, going to have to get up in front of a jury of 12 strangers and repeat her story about what happened and how she felt, and the judge's actions in removing, accepting their withdrawal, that has the potential, if that doesn't get straightened out, that could cause a reversal. If it doesn't get straightened out and clarified, this thing could go to trial. There could be perfect evidence, good, solid, believable evidence. Mr. Allen, or maybe somebody else in the future, gets convicted. It could be appealed. And if it's determined that his attorneys were removed improperly, it would be reversed, and it would have to come back for a new trial. And so the point is, when I gave by Sonny and said, where'd you get this? This is good to make this point that you shouldn't feel conflicted. And I think Alexa would agree with this, and I'd like her input on it, that she, is involved in as a criminalist and profiler, and most professionals, whether it's forensics or profiling, or they want good, competent counsel for the defendant, and they want a good, fair, accurate judge on a case, so you don't have to do it over again. I don't know if Alexa's had any cases that they got a conviction and then were reversed, but I can tell you it's the worst possible thing that can happen to a victim or a victim's family. But I'd like to hear what Alexa thought about it when she was reading the case.
No, I mean, I totally agree. I mean, I did have a few cases. I never really follow them like that closely at that point. But I mean, some of them did get reversed on technicalities. And especially, you don't want technicalities, anything that to do with the judge or with the lawyers. Because anything, if, and like you said, anybody, I come from Europe, so we have a different mentality over there, because over there is, in the United States, is you are innocent until you're proven guilty. In Europe is different. You are guilty and you have to prove you're innocent. So to me, it's a little bit hard, but I do understand now. So one of the things is, I agree. The first thing we want is the defense to be. The defense, I mean both, but especially the defense, to have all the information, to have everything, because we don't want this to be reversed on a technicality. And we all want justice for these two girls, for Abby and Libby. So the best that we can do is get the appropriate lawyers, get the judge. So now my question, and I want to play a little bit of devil's advocate, and I just want your opinion on this. When I was reading this, I started questioning, is she the best judge for this case? And I'm thinking, with everything that's going on, would it be better that she steps down? Can she continue? I mean, is this something that we can recover and say, hey, let's move on and we continue? Or after reading this, in the back of my mind, I'm thinking, well, she has now a precedent that she has violated the defendant's rights in the Sixth Amendment. Do we want this in this case?
Okay, let's go ahead. Let's go ahead and read the relevant for that. Do you
want me to put it back up?
Is that the email you're talking about, Alexa? That one? or reading what? Was she talking about reading the court opinion?
No,
Well,
when I
she-
was reading, the Ramirez case.
The Ramirez
And also
case.
Oh, yeah,
emails.
okay.
The emails made me think something
Yeah.
else. Forget it.
Yeah. So, yeah. Okay. Well, I haven't looked yet, but I don't think there's a lot of cases out there where Judge Gold's been reversed.
I'll be right back.
Yeah.
That opinion is troubling. That she, but a court of appeals affirmed her, and then it took the Supreme Court. I don't know if it's to the point that I'd say that in isolation is, she's not the right judge. Judges hate to get reversed, and most judges, not all, most judges learn from their mistakes, if you will, and learn from them, move on, and take it in stride. I see some, but I'm not a psychologist and I'm not a body language expert, but I see some potential for her used to being running things the way she wants to run them in her county, not used to people calling her out or questioning, especially maybe attorneys. And that, how some people react to constructive criticism, how they react to legitimate discourse. Some become overly defensive. I would say I'm a little bit concerned about a couple of things in these emails, but I'm concerned that there's so much. Let me boil it down to this. What I'm most concerned about is there's so much behind the scenes going on under her direction and control. So she's clearly condoning setting up private stuff and private discussions and things not being fully transparent. She got called out by some media organization. Well, it was Murder Sheet filed that motion, and then a couple of days later, there's a 118 motion drop. She can't go after the media. If an attorney maybe had filed that, who knows what would have happened to that attorney. But in any event, I'm concerned that she's so comfortable with, by email, saying we're going to meet at 12:30 and don't take any further action on the case. I'm concerned that after this thing transpired in chambers, she comes out on the bench and, in my view, tried to create a subterfuge that, well, we've had an unexpected development this morning. Both attorneys quit. That's what a lot of people came away with, that these attorneys were scumbag. They did this stuff with the leaks, and which Rozzi didn't have any part of at all. And
but this was an ongoing problem.
These guys just bail on their bail.
This was
bail on their
situation.
client first
And
opportunity.
Part of it.
Travis.
Back in December of 2022, Rosie was the initial party from the defense that created an environment that information came out. So this was an ongoing thing. I think this was there were multiple
straw that broke the camel's back.
Yeah, there were multiple infractions that were, were caused by the defense that, I think led this set of circumstances happening. It wasn't a one-off.
Yeah. Yeah. Okay. Thanks for clarifying on that. But it's clearly a waiver. If she didn't do something about it in December, she can't take him off in October for something he didn't do in between December and October. I mean, or she's got to explain that. But it's all going to come out, and they've talked about this list of allegations that she was prepared to read in open court.
Read it.
I don't think she was prepared for it, but it's mentioned in the writ. They're giving her an opportunity. She's going to have a full opportunity. Now, she'll be represented by the Attorney General's office, I believe it is, in Indiana, who will be filing the official brief on her behalf, although she has the right to file anything she wants on her own. But,
So
representing yourself, you're a fool for a client, but it's all going to come out, and she's going to be, I know she's stewing about that. She is stewing about it big time.
I mean, it all should come out.
It's out there, which is why
everyone should be held accountable for their actions. I think Andrew Baldwin should be held accountable for his actions. Brad Rosie should. Judge Gull should. Nick McClellan should. Everyone should be held accountable for their actions. I think the action that's the decision that's before the Supreme Court or this or the appellate court, not the appellate court, the Fifth Circuit Court. I think that it's important that they make a decision on if everything Judge Gull has done is appropriate. But it is important to note that as of now, there has not been any official finding that Judge Gull has done anything improper. Yes, there are questions, but we do know that there have been things that have been improper done by one party in this. And I have a question about that when you were talking about if setting something up for an appeal. Can the same be said, if let's say hypothetically Brad Rosie and Andrew Baldwin are reinstated as Rich Allen's attorneys, and they go about this trial, but could it be argued that they created such a distraction, and that at any time, even if after a conviction, Richard Allen decides that they were an ineffective assistance of counsel, couldn't they themselves be setting him up for an appeal?
That's been the kind of the subject of some really good detective novels and movies about setups like that. Anything's possible, but in reality, the chances of getting a case reversed on ineffective assistance of counsel, you just have a better shot at winning with the jury, just getting one juror to be a holdout. And so, I mean, it's possible, Adam, but the reality of it is it's not easy to get a reversal and when we say on a technicality, those technicalities are constitutional rights. Those are the technical things. And it is not easy to get either on direct appeal or a motion for post-conviction relief. I mean, it's 1 in 1,000 or less that these cases get reversed. It's got to be glaring. And for her to get reversed on something so fundamental, it's concerning in the Ramirez case. Now, with the writ, these attorneys through this writ have said that either Judge Gull or the clerk or both are acting improperly. they've made the allegation, and the Indiana Supreme Court has said, we find there's enough merit in what they've brought forward in the brief. Now, they're not commenting on how solid it is, but they're commenting on it that they've laid out, again, more Latin, a prima facie case. They've laid out enough of a case that, if true, if it doesn't have a reasonable explanation, for example, I didn't want to overburden the clerk's office with having them put 118 motions, documents back into the system, that there's either, not a good, reasonable explanation for it. They've said, we want to hear from you. You need to respond to this. Otherwise, we're going to order it. Now, what is it that she's alleged to have done? It's, keeping stuff secret or not going through the proper process of filing this form if you think it should be confidential. But this stuff about removing them, it got included in the writ, but there was nothing, really. They're not asking for any relief for that.
The Supreme Court's not going to tell
reinstated.
Down.
Right, because the proper avenue for that is, again, that motion for reconsideration. If there's a denial of that, then you do what's called an interlocutory appeal. You don't do a writ. Now, if the process on that motion to disqualify is that it be assigned to a different judge and she refuses to do it, if they come back in as counsel, he refiles the motion to disqualify for not being fair and impartial to Richard Allen, and she said, no, I'm dismissing it out of hand. And it's like, Judge, this rule says right here, it's got to be heard by a different judge. Then they'd be able to bring a writ for that, a writ of prohibition or mandamus, because, again, a writ of prohibition or mandamus is only for violating something that's clear, non-discretionary. You must file this form if you want to keep it confidential or secret. But your points are very well taken, Adam, that there's always two sides to any story. All we have now is allegations in the form of the writ, and that we know that there's enough there that the Indiana Supreme Court wants a response, and we'll just have to wait and see for that response. We'll also have to wait and see how she reacts to them willing to come in on a pro bono basis. And
that's going to be interesting tomorrow. So do you think tomorrow is going to be a go? I mean, what can we expect? Do we expect, I guess, 4 lawyers showing up tomorrow?
Yeah, that's what I was going to ask. Thanks, Alexa.
They probably want to know too.
Adam asked that exact same thing 3 hours ago. Adam, have I elucidated you in any manner that you have a better answer to that, or is the answer the same? I don't know. All I know is what she said from the bench that you all heard last week. It was supposed to check with counsel, possibly setting a new trial date. And of course, nobody expected, although we kind of hypothesized, what if they wanted to come back in as private counsel?
Right.
And
but is tomorrow a go, though, regardless?
From what I know, no way she can prevent that.
Right.
And that would be grounds for another writ. So let's try and answer some questions.
Yeah, I mean, I would think by, the fact that the hearing's at 9 a.m. tomorrow, I would assume that, the court's going to, the transport orders there, I would assume things are going to progress probably, if anything happens, it's going to happen at the last minute, and we're going to hear about it just like we did on the
Last
19th
week, yeah.
at the last minute.
So, yeah, and I just wanted
Now,
to ask myself.
did she grant another order to televise? I saw one order said because
She's
of
not
improper
televising.
activity, I'm
Right.
denying the motion
Right.
for cameras.
Yeah, it's denied.
But
So,
she did issue an order about a bunch of rules about attending the hearing tomorrow, right?
Yeah,
correct.
decorum. Yeah.
Yeah.
And I think they're going to take the cameras like on a hearing by hearing basis.
Yeah.
Because Carroll County is not fully set up yet for televised cameras, whereas Allen County was.
Yeah.
So I think that was part of what went into that, but that's just me speculating.
We probably should go over the emails.
Yeah.
Yeah.
The next show, y'all want to talk about it because they're important. Because
Yeah.
there's an email in there that's concerning to people like Sonny, Adam, Murder Sheet. She put in an email.
Which one do you want me to scroll down to?
That content creators, she may use a different term, are not journalists. Therefore, I'm going to issue an order that if they don't return the stuff, and then they can be arrested.
Yeah. What's about? I was like, what?
Murder Sheet filed a motion, and that they're a content creator.
Yeah.
And
the third party.
I mean, we need to save that for next time. We need to read it and see what people think about that. But I mean, I'm a big First Amendment guy, and I don't care what the issue is. If you're in the Ku Klux Klan and you want to argue your thing,
yeah,
First Amendment. If you're a Odinist, you're not allowed, as Alexa pointed out. That's why they're called a uniform. You're not allowed to wear patches, either a cross or a Star of David or an Odin patch on your uniform. I don't even know how that happened, but it's or a black Muslim, and prison guard, police. We just don't want our police officers and our prison guards wearing patches, and it's not an infringement on exercise of religion. It's been repeatedly held. But anyway, that she could think that she can order YouTube creators that received
photos, whatever. Yeah.
Photos. I'm not condoning what happened, what led to it, but she's got some worrisome ideas on who she can lock up that refuses to return photos.
Well, let me, because how do you return a digital photo? I know what my experience was with interacting with law enforcement and the officials over some of this leaked information. And I complied with everything I was told, in regards to that. But a journalist in in this country, a journalist is really afforded no more rights or liberty as anyone else, as far as, if an investigator contacts you and they ask you for information, of course you don't want to give up your source. But if you're compelled to by subpoena or by, you don't have the same liberties that a lawyer or a doctor have as a journalist. So I didn't really take offense to that, content creators are not journalists, because there's really no liberties that are afforded a journalist that wouldn't be afforded to an everyday citizen. And just that was the way I took it.
Because you guys are too young to remember when the Pentagon papers were stolen during the Nixon administration. There was a guy that worked at the Rand Corporation and so he stole top secret documents about how the government proved that the government, specifically the Johnson administration and the Nixon administration, had been lying about the war and whether it was winnable for years and years. And finally, the man who stole those top secret documents, he sent them to the New York Times and another paper, I believe it was in Kansas City. And the Department of Justice, you know, the New York Times editors called up the DOJ and said, hey, we got these documents and we're going to run them. And they filed an injunction, the DOJ did, on behalf of the Pentagon to prevent the release of those papers. And it went all the way up to Supreme Court. And Supreme Court said, we're sorry, but you cannot force somebody who had nothing to do with the leak or the stealing of documents, and they receive them. You can't just come in here and say, oh, national security. That's not enough. This is now the New York Times property, and you have to come in and justify that taking. So y'all do have right if you weren't involved in it. In other words, if you weren't somebody that paid to steal a videotape of Jesse Ventura or steal a video of somebody. But, you know, that's the big thing now is home porn movies of celebrities are what gets stolen now, or seems to be the thing du jour. And they've ruled that, you know, too bad, unless you're underage and a minor, you know.
Right. Look at Pamela and Tommy Lee.
Yeah. Mm-hmm.
They didn't make a dime.
So, yeah. So this stuff about, you know, and that email is just, you know, tragic about, of course, that email is going to stir up a million. I mean, the wife says, he said, hey, I'm going to be fine if I just come clean. That doesn't sound like somebody's suicidal. So, people are going to do what they're going to do. They're going to say, oh, well, you know, law enforcement must have killed him, or, you know, the DA must have, I don't know what people are going to say. People say whatever they're going to say, but, you know, that's what's never ending. But, you know, you raise really good points about all of this, Adam. You know, what is she going to do tomorrow? And if her position, well, I can't prevent him from coming in. Sorry, Mr. So-and-so and Mr. So-and-so. They're
probably going to be like, okay, we're good. We're leaving. Bye. Those two new guys are probably like, we don't want anything to do with it. Bye.
Yeah,
But, you know, a lot of people speculate, well, you know, the defense attorneys that do this all the time, it's like, well, you know, they probably did this on purpose because they wanted him off. Or I've heard comments that, well, they realized he was guilty, and so now they want it off the case.
No,
that stuff factors into a defense attorney. It's your mandate as a defense attorney is one thing: put the state to their burden of proof in an ethical way, and you have the presumption of innocence, and as long as you have that, and you have jurors that really believe in that, the system works great. You know, but, you know, I don't think the judge necessarily needs to be removed. I don't think these attorneys needed to be removed, but that's moot now because they're back, so she'll say the motion to disqualify, if those judges are going to come in, that needs to be heard by the appropriate judge, and they may rule no, we don't see any evidence of impartiality. Move forward. That happens, or they do, and it reassigns to somebody, or she says, you know what, I don't need this crap. I've been the judge for 20 years, reelected 3, 4, 5 times, whatever it is.
I'm on my way to the Supreme Court.
I was trying to do the state of Indiana a service. I just really don't need the headaches. One of you young bucks take it. And, I don't like to see the abuse about the judge and the attorneys. Where the attorneys were referred to as clowns.
Really?
It's just, I've heard it was, it doesn't matter who it was, but they're clowns. Those guys aren't clowns. They're battling it out in the trenches on behalf of their clients. And I'll guarantee you, these 3 bitches ain't clowns. They're going to be so far up her ass, she doesn't know what to do. So, I dare them to call these gals clowns. This is the creme de la creme of Indiana lawyers, and they're lead pipe carrying sons of bitches, like Hennessy is, and so, and it will get worked out, and there needs to be accountability. So if they come in and the disqualification motion gets resolved, whichever way, she's still on, she still wants to be on the case, then she should tell them, okay, look, everybody's starting with a clean slate. Everybody, me, everybody, everyone's starting at square one. But I'm going to tell you right now, and she should say this on the record, in public, in front of everybody, there's going to be 0 tolerance on this gag order. Does everybody understand? Everyone deserves to be set back to square one. That's how I'm going to treat everybody. But I'm telling you, there's not going to be any more messing around with this gag order, or the consequences will be dire. And then what she can do is either fine monetarily or put people in jail. And then everybody's held accountable, and I just see all kinds of crazy stuff. She should be recalled as a judge. The attorney should be disbarred. And I'm going, I'll just tell you a quick personal story. The effort to get crime scene photos is as old as the moon. What's that case in LA? The black, they cut her in half.
The Dahlia. Black
The
Dahlia.
Black Dahlia. And they got those crime scene photos, and the newspaper guy paid some beat cop money, and that's how they'd get it. And then the tabloids would offer big money for crime scene photos. And I had a guy in the 80s that he was stealing. They were grabbing our garbage, and we finally caught them somehow. What the hell? And they're like, oh, we're from such and such a paper, and we were going through your garbage hoping to get something on the case because you won't talk to us. And well, we can't talk to you. So long story short, we got shredders, and then eventually we got a shredding service to come in and um, you know, we mark stuff burn, and it goes in a burn bin. And I don't know if they burn it or not, but the volume of paper is so voluminous that we would burn up our shredders. We had a commercial service. They come in, pick up the burn barrels once a week or once a month, and then it goes through a DOD certified shredder, not the long strings that you normally see. It puts them out. They look like confetti that are the size of the head of a pin that you'd never be able to piece back together. And then they're under a bunch of agreements that they're DOD certified, and but that's the state of things, and hugely unfortunate, and that's just the nature. But I think this thing can be put on the right course. I don't think the judge should have welcomed the motion to disqualify. I don't know if there's there wouldn't be enough in Texas for her to be disqualified. She said, "Oh, absolutely, you betcha." But doing stuff like, I'm going to strike that and order it be removed from the system, it's just not allowed in Indiana or anywhere else.
But I do think it's important to note that, yes, I mean, I get that it's not going to make or break your case, but I mean, in a protective order, gag order case, when there are repeated leaks coming from one side, not both, but one side, it should, and I feel like would be irresponsible for them not to confront and deal with it.
Yeah, but why do it in secret?
Well, if
she's real about it, what you do is,
I don't. One of those emails, the defense said this leak didn't come from us.
On? Where did this stuff come from? Okay,
right.
You're in contempt. That's $1,000. That's $1,000, Mr. Rossi. Do better. That's how you handle it. What's all this secret crap? It's just not done.
In one of these emails.
It's just, and then I'm going to arrest these local content creators. They're not journalists. I mean, it's scary what she's putting in writing, and
can she actually do that?
She's stewing over this because she's going to have to explain it.
If you compel someone for a source and they refuse to get it up, technically, yes, you can be jailed. But I don't see that happening. But I mean, the defense even in this,
she said, if they don't return the photos,
well,
I'm putting them in jail. That's what she.
How do you return a digital photo? Because I mean, I can speak to this firsthand because
apparently that's no problem for her.
Well, I mean, I can speak to this firsthand because I received the information that we're talking about, and and the very first thing I did when I received it was I contacted law enforcement, and I contacted the defense and the prosecution to inform them that I was given this information, and what I was told was that an investigator would be in touch with me, and that I would need to send them the pictures, so they could have my metadata, I presume, and that after that they asked that I would delete the material, to which I said absolutely, and I didn't share it with anyone. I didn't do it. Because to me that was the responsible, ethical thing to do. And when I read this email about what she's talking about, that when they say return the photos, that's pretty much what I'm taking that as. People, like they asked me, they said, send us the pictures that you received, and then delete them from your phone. So when they say return the photos, I assume that's what they meant.
And then,
what do they do? Mail them in? Here, let me just print it off and mail it in. Obviously, right. It makes it only meaning at the end of the day, someone could go, okay, yeah, I deleted them. Okay.
Of course. they didn't ask for verification or anything like that. But
Well, exactly.
but
So
when they
it just-
return the photos, I believe that like when they asked me to like send them the pictures, that way they have the digital footprint of like the metadata from those photos.
yeah.
Yeah,
I'm sorry,
you
but that
know,
whole
and
thing doesn't make sense.
it happens on both sides.
I'm
Go
sorry,
ahead,
Travis.
Travis.
Oh, I apologize. I interrupted Sunny. I was
No,
just going to
I
say
was-
it happens on both sides in any given case. In this case, all from one side, but it's there's nothing I've seen that rises to the level that you're removing somebody. But to me, it but even if that's okay, then this stuff about I'm going to remove documents from the record. That's why it's covered so much in this brief, and why so she's going to react a couple of different ways. She's going to react either she's going to take it personal, and then you'll see evidence of that tomorrow, or she's going to take it in stride that it's part of the process and move with it. And if she continues to take this stuff personal, which she's exhibited, and trying to put a positive spin on things like, we've had an unexpected development that's blown up in her face, and how easily that tripped off her tongue. I don't know what the wiping of the mouth was. Maybe Alexa can explain that for us, but she unexpected development. They've both quit, both oral motion and withdraw, and the unexpected development. And I don't know, it's just baffling to me, the thinking when it could be so easily should have just come out and said, hey, look, we've had 5 leaks. I've had enough of it. They're appointed counsel. Enough's enough. With appointed counsel, I have the authority to remove attorneys for violating orders. And I gave them a choice back there that they could either voluntarily withdraw, or we'd have a hearing and I'd listen to the evidence and reach a conclusion. They both decided to withdraw. So they're both off the case. Mr. Rossi is going to file a written response he's going to get in a couple of days, but as of right now, he's officially off the case. I'm going to have a couple of attorneys appointed in a few days. They've told me that Mr. Allen, who I've asked be brought into the courtroom and sitting right here for the record, then asked me to inform the court that he opposes their withdrawal. I understand. However, the court's not going to continue with this, and I've given them every opportunity, and I'm just not going to go forward with them anymore. And I know you're opposed to it, but the court will select very accomplished, very experienced attorneys to replace them. And I have every confidence that you're going to have the same trust and confidence in those lawyers as you have with Mr. Rossi and Mr. Baldwin. Anything from the state? No. That's my ruling. Stand adjourned until the 31st, and we'll see you back then. we'll talk about who the new attorneys are going to be, and we'll all work out a trial date that works with everybody's schedule. See you in 2 weeks. Just as simple as that. That's what the big timey trial judges do. Not trying to put any spin on anything. It's just boom, call balls and strikes and move. I just don't understand some of it, but
Was Travis,
Not
was
taking
she
it personally, I think, because she took it personally. And I remember when we were watching the video, I said that it got to the point at one point, like she was almost like suiting herself, what we call suiting, because I think she didn't expect them to quit. I think she was the one. Sometimes, ego gets in the way. And like you said, when they wear the rope, they are the ones in charge. They want to dominate, I guess. And I think she thought that she was going to tell them, basically you're dismissed. And I think she didn't expect them to say, no, you know what, I quit. And I think that's what threw her out of, because in her face, you can see it in her face. Like she was like shocked, but at the same time, she was upset. And you can see her hands, like how she's clenching her hands. And you could see how upset, and at one point you can see like almost like suiting herself, like saying, calm down, like don't let it make it so obvious. So it's going to be interesting, and I think that's the thing with her. I think this whole thing it's becoming it's becoming an ego, like who has the bigger ego, who is right, and we're forgetting why are we doing this, and we're forgetting those girls, and we're forgetting the families. And I feel awful because this is just delaying more and more and more and more.
Travis, I want to ask you, do you agree with Alexa's assessment from what you saw of the judge and how she was talking? And then she was, I see it a little bit differently, like slightly. But what do you think?
That's not my area. I'm focused more on the words and what she said.
Well, that's what I mean. What she said there at the
I
start.
I have to be in the room, with a witness, and I've got to be in there to where, I can get a vibe off of a potential juror when I question them or when I cross-examine a witness. But that part about we've had an unexpected development. I think I have
that's
that
what I'm
quote
talking about.
That really troubles me. That means that she was trying to suggest something that didn't happen.
Yeah, that's the
She
part that troubles me
lied.
too. Sorry?
She developed this plan, this scheme. She had a prepared thing
How it was
with
gonna
different
go.
items that they were grossly negligent on. It was a bad tact. I wouldn't be surprised at all. And those judges have associations, and you have mentors and whatnot. But I wouldn't be surprised if she called a mentor type judge and said, "Hey, give me your honest opinion." And I would be surprised if she wasn't told, I would have handled it differently. I would have ended up at the same spot, but I would have handled it a lot differently. Public defenders that work for a true public defender office, that you're employed by the state of Indiana, you get a paycheck from the state of Indiana, from public defender's office. It's different. You can push around those people a little bit more. The attorneys who were qualified for court appointments and are at a capital murder level and make that maximum hourly of $167 an hour. they have practices. They're with firms. And again, like I said, Razi's firm is from a very old time firm. He works for his father-in-law. He's got 3 or 4
Alexa needs to get going, Travis.
school districts. And
Have a good night. I'm sorry, I gotta run.
No, you're fine. Good night, Alexa. I'm not going to be far behind you. I've got to go to bed too.
Yeah.
Bye-bye.
I gotta, yeah, we're gonna wrap. I need to wrap up too, Alexa. Thank you so much for your thoughts on that case, and I really appreciate your thoughts tonight. Thanks, Alexa.
Yeah, I was gonna say we're gonna just because my husband's gonna need to go to bed soon here, and so you know what? Let's just do fine. Like, are you okay to do final thoughts right now, Travis?
I would like to continue this.
Yeah, we'll come back another day. You just let me know, and we'll do the emails.
Yeah,
I would love to continue.
I know that I know that the viewers absolutely love, when they can hear someone with the expertise, and knowledge that we just don't simply had. Kind of like what Ivy was saying. It's nice to come in here without having to read everything, that you don't necessarily understand, and then have someone explain it to you.
I can't recall one thing tonight that either you or Adam were off on legally. It's common
It was
sense.
more Adam. I was
and
just.
So what I do is I affirm your hunches, I hope, and based on the questions I've been asked by both you and Adam, and so that's helpful. And then can answer some questions. These are my final thoughts. And answer questions of the viewers. And then the other thing I hope I did is Adam has a view on it, and you and Adam know the case infinitely better than I do. Going back to the time of the horrible crime, and then going through that period of what the hell's going on, and then I mean, you all have been living this for years, and I'm just coming in giving this dry, sterile,
but that's good.
Triage of these crazy developments, but
I mean, I think that's good because you don't have.
That's what makes it so great.
You don't have 6 years or 7 years of an emotional attachment to it as well. So I mean, I think it's right. Beneficial to hear someone not only from your legal expertise, but also someone that can just look at this as that doesn't have this emotional attachment to these victims and this crime, which because I think we all try to be objective, but it can be difficult sometimes when you.
Oh yeah, yeah, very much so. But I just wanted to also finish by saying that because Sunny getting me all of the documents, although it's morphed, she was sending me documents over the weekend about what was filed last week, and then worked on that, and then this morning she said, "Hey, have you seen the writ that got filed?" And I'd been telling people that we're going to see a writ, and then we finally did. And I said, well, we should just go to the writ. And then I worked on that this morning, and then she sent me another thing. But the one point that, and I think we made, and I hope people understand, is no matter where you are on this case, I realize different channels have different focuses. And Defense Diaries may be from a more defense perspective, or this channel over here is more from the victim side, or your channel might have. It seem to be very fair, but just be respectful. But no matter which side of this you're on, that if the ultimate goal is justice for the girls, the only way to get to that is that there is a proper defense for the defendant, right, and that he receive a fair and legal trial. And sometimes that's hard for people to grasp because it is very emotional. But Alexa found that case where there's horrible crime, and the attorney said, "Hey, I was just advised yesterday, day before trial, that they're going to be going for, excuse me, digital penetration, which is 20 years to life versus rubbing on the outside of clothing." I'm assuming it doesn't say that in the thing, but it's a night and day thing.
Right.
And I need some time to come deal with this new information. Nope. And then it talks about, he made, even during the trial, a judge, respectfully, I'm renewing my request. I need some time. This is all brand new. Nope. They said the failure to entertain a continuance of even one day denied him of a fair trial. And so got to do it all over again. And
Yeah.
but you know,
Well, it's definitely going to be interesting
I
tomorrow.
don't think we need the crazy reactions about the defense attorneys. I don't think we need the crazy reactions about the judge. There are some concerns about the attorneys and their ability, to keep this stuff where it belongs in the future. But I'm sure they can adequately explain what they're going to do to prevent anything going forward. The judge can get things in perspective and get in compliance with the law, assuming she's not in compliance on the filings and whatnot, and this thing can go forward. But there was a huge shift, and tomorrow's going to be very interesting. And I guess we're going to be getting that piecemeal. We're not going to be getting tweets from the courtroom.
No.
I guess they'll cycle people out every 15 minutes to give an update and then do it that way. But
yeah, usually we have
tomorrow's a
some
big.
friends.
But those were my final thoughts, and I can't see the comments, and so please don't think I'm ignoring whatever
Okay.
you're saying in there. Your people, I don't see the comments in the stream.
Are you on your laptop?
I'm on my laptop, yeah. But so I'm not ignoring folks, but thank you for having me, and
Thank you.
Always
Well,
a pleasure.
No, I mean, honestly, from the bottom of our hearts, we're thanking you because it was so great. It's honestly a pleasure and a treat and a pleasant surprise. I'm so glad you came into the chat the other day, and I know like you and Alexa were talking throughout the live and stuff like that. And I don't know what it is, but I always think of Esquire as almost like a British thing. I know what it means. I know it means a lawyer, but I don't know why. I don't even know if Esquire where that term.
In England, it means a gentleman. In the U.S., it means you're an attorney.
Right.
Well, but anyway,
and those two are not always the same.
Yeah. Adam, did you want to give your last thoughts for tonight?
Yeah, no, I mean, I agree. I mean, thank you very much for coming on. And, and I think, I think regardless of, where, someone's mind is as far as, Rich Allen's guilt or innocence or what's been proper or improper in this case, I think that I don't think anyone should disagree with the fact that it's in everyone's best interest that, like you said, Rich Allen get representation, whoever that may be, that the judge is improper or the judge is proper, and that and that he gets a fair trial. Because I mean, also, tomorrow marks the 1-year anniversary of the press conference in which we learned of Richard Allen's name. Of course, he was arrested on the 28th, but he's now been incarcerated for 367 almost
Yeah.
368 days. And
Yeah.
I mean, any delays in this case, you know, not only affect the girls' families and Richard Allen's families, but also Richard Allen. And so, you know, I think it's in everyone's best interest that he get a fair trial, and that everything be done above board and in a transparent manner. So I know that I probably come across sometimes like I'm very pro prosecution, but I'm really I really am, you know, objective and fair as far as I want everyone involved to have the to be held accountable and to have like the best situation play out the way it should.
You know, I was going to say, Adam, you know, for me personally, and I know for us, bottom line is we're here for Abby and Libby and justice, you know, and for, like I said, for Richard Allen, who's ever guilty to be, you know, tried, that the proper person is tried. Simple as that. That's the bottom line. That's been the goal the whole time. I know that there's people that have some crazy conspiracies and out there and stuff like that. But the bottom line is that, and some people do forget now, you know, this is about Abby and Libby and the justice for the truth, you know, and of course there's a process to that, you know, and that's all we want to see out of this. Fair trial. The proper person is brought to justice for Abby and Libby. God, I'm going to get upset now. They deserve it. And it's been a long time. Yes, does this stuff tick me off that this process is getting twisted and turned in this direction? Absolutely. Why? Because Abby and Libby, their parents, grandmas, grandpas, their whatever, relatives, you know, they're the ones suffering here at the end of the day that have to keep dealing with all these twists and turns, and they can't bring any sort of closure yet. And we're into our 7th year, okay? Coming up February 13th, it's the 7th year for Abby's and Libby's case. Amazing that it's, you know, 2017 to 2023. It's frustrating, absolutely. The law certainly doesn't work in a very fast way, you know, with all the different motions filed and blah, 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 blah. And you know it's going to be a long time. But at the end of it, I always believe that things are meant to happen for the reasons that they do. And if this becomes that Richard Allen has new lawyers and that's the way, you know, like the stars aligned, or the, you know what I mean, the universe said that that's the way they wanted it, then that's the way it's going to go. You know, I'm patient, but I'm not patient, because I'm just, it's heartbreaking knowing that you're fighting so much for truth and justice for Abby and Libby. Libby left a video, okay? You know, and that's always been the thing that always sticks in my head is Libby's like, here's the person on the bridge, you know, and please, you know, basically bring us the justice, you know. So it's just one of those things that I'll never forget, that we have to fight for Libby and Abby first and foremost, you know. But anyways, just want truth, justice, fair trial, you know, everything to be up and on the up and up and, you know, fair. But that's all. Now, what's going to happen tomorrow? Who knows? Yeah. Okay. But anyways, yeah. So we'll see what happens tomorrow. No clue, to be honest with you. As far as you're concerned, Travis, tomorrow's going to go on from what you're thinking that is going to happen, and it's just a matter of maybe.
Well, I think something's going to happen. You know, it's scheduled, and even if it's her coming out and saying, sorry, folks, it's deja vu all over again. We've gotten some filings with the other attorneys wanting to come back on. I need to take that under advisement, or or it could be a really, or it could be a real ugly mess, and you know, but
well, hopefully not. I feel like, you know what, we'll just see what happens. We'll just see what happens.
And then we can talk about it, whether it's tomorrow night or whenever you want me back. I'd be happy to come back.
Yeah, tomorrow, like, this is Halloween now. Like, I am so far behind on Halloween stuff.
I can't do tomorrow. Yeah. And,
Well,
I'm on vacation till the end of the month or the end of the week.
Well-
I mean,
Maybe Wednesday night.
Yeah.
chances are, I'm sure there'll be a live tomorrow at some point here because, once the information comes out, we're going to be talking about it for sure. I mean, honestly, this case is more important to me than Halloween. Okay, I mean, Halloween's nice and whatever, and I just do it really because, why not? If anyone's bored, they can just come chill, chill with me and whatever, do Halloween. But we'll see how tomorrow plays out. I thank you so much, Travis, again for your time.
It's my pleasure. Thanks for inviting me. I hope it helps some people.
Of course it did. It helps us. It helps them. Whenever somebody, like I said, it's not our forte. Put us in, Adam does really well. Like I said, I know I'm in Canada, a little bit further, like a little bit different rules over here and stuff like that. But Adam's always been a lot more. Let me put it this way, a lot more.
Oh yeah,
Understand
absolutely. From what I said, what I've heard in the past, Adam will say, "Well, I'm not a lawyer, but I think it means this," and
exactly. But anyways,
always on it,
Yeah.
Thank you.
And this is just so you know too, like Halloween is Libby. This is her favorite holiday. So, just ironic how last year it fell on Halloween for the press conference. This year, like I said, another date on Halloween here. Again, Libby's favorite holiday. But with that being said, you guys, thank you guys so much. If you haven't hit that like button, hit the like button. Thank you so much to Travis, and I know that the viewers totally appreciate it as we do. And other than that, we're gonna head on out of here, you guys, and we'll see you tomorrow. Definitely see you tomorrow. Take care, guys. I'm just gonna play the intro. This is Sunny Justice and Aspen Connor from It's a Crime and Shame, wishing you all a good night.